Beg to mention item number 7 and 10, my lord. I have some personal difficulties, not feeling very well. Can this be taken up on Wednesday, my lord? Some urgency in both these matters.
7 and 10.
7 and 10. I've
Okay.
informed
When
that.
do you want?
Can it be on Wednesday, my lord? There's some urgency.
Okay. 7 and 10. Both sides are represented on the prayer made by Mr. D.K. Panging, counsel for the petitioner, list on so and so.
Obliged.
May I please, my lord? My lord, one WPC matter pertaining to the transport is being filed this morning. Therefore, my lord, this may be taken up today at the unlisted. matter.
What is the matter?
My lord, matter pertaining to the transport. My lord.
Transfer.
My lord. Obliged.
I also want to mention unlisted matter, bail matter, Your Lordship. Maybe bail application.
Bill.
Yes, Your Lordship. Much obliged.
Lordship, I beg to mention item number 30 on behalf of Titi Tara. He is out of station, so matter may be list after puja vacation.
List after 4 weeks as paid for by land counsel for the appellant.
Lordship, one more. Item number 31. I'm on behalf of Titi Tara. Here, I was instructed to withdraw this matter since the matter has already, since the purpose of filing this writ of petition has already been served and he received a retirement benefit and even this petition is no more.
Petitioner is no more.
No more.
And he has got the money.
Yes, he already got retirement benefit.
Okay. Both sides are represented. Upon instructions, Mr.
Taba Tukur. Taba Tukur.
Tawa.
Tukur.
Please give this spelling. Learned counsel for the learned counsel appearing on behalf of Mr. Kitara, counsel for the petitioner, submits that the petitioner has expired during the pendency of this petition, but he has been given all his retirement benefit. Next paragraph. Therefore, upon death of the petitioner and on satisfaction, this petition stands closed.
Deeply.
Bless you.
My Lordship, I beg to mention item number 18, my Lordship. Conducting counsel is out of station, my Lord.
Item number
18.
counsel for.
I'm appearing on behalf of Omodi.
Okay. You have informed the other side?
Yes, my Lordship.
Okay, with consent of the other side, the counsel for the petitioner plays for adjournment. Prayer is allowed. List after a week.
My Lordship, stay order may be continued, my Lord.
Interim order passed today stands extended till the next date of listing.
Mayor Lordship, I beg to mention item number 8. Mayor Lordship, I need to file a rejoinder, Lordship.
You are going to file?
Yes, Your Honor.
Okay. On the prayer made by Mr. B. Tapodia, counsel for the petitioner, list after 2 weeks.
Obliged, Lordship.
My lord, I may be allowed to mention item number 20. Service report is still awaited, my lord, here.
Service is awaited.
Yes, yes.
11:20. You take first steps. Counsel for the petitioner and Randy Rehiti are present. Next color. As notice is not served on the respondent numbers 1, 2, and 3. The petitioner shall take first steps for service of notice on the said respondents by registered post PBB. Where is the complaint? Where is your complaint? But tell us, shall take steps within 2 days. Make it 2 working days. The notice is made returnable on 6/11/2024. Next, this on 6/11/2024. Take first steps.
Obliged.
My appellation. My lord, the civil division has been prepared against the order passed by the civil judge senior division that the 21/8/2024, wherein my lord, while my lord, the order was passed, while quashing the order that the 26/9/2022 and 16/10/2022, the order that the decision that the 27 or 21/7/2019 was also set aside, and the court has decided to take up the matter in the de novo trial. So, my lord, my basic grievances before this honorable court to review is that the civil appeal has been allowed, but including this order that the 21/7/2019.
Where is the order of the,
My lord,
customary court?
my lord may kindly come to page number 111,
111.
my lord. This is the continuation which has been started from 100. Operating portion is in the 111. It started from page number 99. Where in the my lord got it? Triple one, 111.
No, the order of the original court. This is an appeal.
My lord. This
This is the
is
appeal
the
for
order
original-
out of the appeal, civil appeal.
No,
This,
not this, the original order of the customary court. Original order of the customary court.
my lord.
Where is that?
Original orders of the customer. There has been two original order, but the order which has been challenged is before. My lord may kindly come to the page number 44. Forty-two, my lord, sorry. This should be start from 42, my lord. This was the original order passed by the customary court. My lord, despite of reading everything, I'll like to prepare, my lord, start from para 1. On the basis of the unequivocal narration of the past history and the social memory record, it is explicitly justified and ascertained that the place name such and such, my lord, they should not to require, mention all this, belong to such and such of the Yak clan. In order to maintain the community of the common glory of the memory and inherit the past history, the toponym and the territorial legacy and inherit right over the Totu Papa and its adjoining area hereby declared that no individual or the villager or the group shall have the right to claim any ownership and take over the possession upon the plot of the land from the aforementioned village, community, forest land area under any circumstances. This is the operating portion, my lord. Say that the area including the Tatu Hapa shall be declared as a village community land and no individual shall have right over that land. Now, my lord, my challenge against this order is basically on the ground that,
And where is the order of 26/9/2022?
my lord may kindly come back to the page 41 and the yes, my lord, operating portion is in page number 41. This is the order passed by the SDO Doimu. My lord, page 41.
Just a moment.
With the above observation,
Just
it is
a moment.
concluded that the history.
Just a moment.
Now, my lord, order 26/9/22. This indicate that the
Just a moment.
Mal-
I'm reading that order. Yes, now tell us what is. Now tell us how you are agreed by this order.
My lord, being aggrieved of this, these two order has been, my lord, set aside. That I am not aggrieved against that, my lord. While setting aside these two order, my lord, the order decision dated 21/7/2019 was also, my lord, set aside. Therefore, I am here seeking for the revision that this order 21/7/2019 should not have been, my lord, set aside along with these two order, because this decision is undisputed. And my lord, may I kindly come to page number 60. My lord, 60.
Yes.
A meeting was held on 21/7/2019 under the chairmanship of Sri Sas and Sas and GB and the resident of Sas and Sas located at the UPA village to settle the long pending cases between the UPA villager versus Gyamar Takar me, the petitioner, regarding the dispute that is the Tatubhapa area of measuring Sas and Sas located at Sas and Sas, and hereinafter its fall within the UPA village jurisdiction. After threadbare discussion and going through the witnesses and the evidence available before the House has unanimously decided to amicably settle the case locally within the village by all the village authority of the UPA as such the following below are settled as term. First one, the House present in the meeting has seen that the maximum and the majority of the UPA village has already put their signature in the NOC in favor of the petitioner and ownership of the developed area in Tatubhapa, my lord, Tatubhapa only. Thereafter, that it has been proved that the aforementioned area has been possession of Sri Gyamar Takar alias Barot since 2004 until that, whereas he has also put his signboard showing his possession. That it has been proved that Sri Sas and Sas has been engaged in developing the area as such the cultivating and planting various previous plant and the trees such as bamboo, mango plant, papaya, cardamom plant, season tree, or jackfruit tree, etc. are investing huge amount. So, my lord, this is the decision. This has, after, my lord, the battle for since 2017, the conclusion has arrived on this day, my lord. And this is, my lord, followed by what, my lord, they have reported the village already major, my lord, the majority has reported, my lord, by the minutes of the dated 13/7/2019, which appear in, my lord, Annexure E1, my lord. These are out of this settlement was done, my lord. Therefore, my lord, my contention is that after the prolonged, my lord, discussion and the, my lord, various sitting over the, my lord, issues, the conclusion has arrived on 21/7/2019. Thereafter, my lord, this order, particularly this is, my lord, settled by the village customary law. So, my lord, this has not been challenged in, my lord, any form, and this has not been challenged by the other party. Thereafter, my lord,
Are you very sure?
my lord,
Are you sure about what you are saying?
I am sure, my lord.
Yes, sure.
They
Come
are,
to page 109.
my lord,
Come to page 109.
109.
Read paragraph 21.
Paragraph 21, my lord.
21.
My lord.
Read that.
The appellant has relied that the document and the deed of the settlement dated Annexure A dated 21/7/2 contained that the dispute measuring such and such at the Tatubhapa belong to him. However, in the order dated 26/1/2000 annexure passed by the Sub-Divisional Officer Doimuk, it is stated that the said foreground Bura has given the decision regarding the ownership of the said disputed land in favor of the applicant has withdrawn their respective signature and consent of the declaration dated 8/10/2019, wherein they stated that their signature were obtained by misleading them by prudently means. So the question remained to whether this deed of the settlement that can be relied upon the settlement declaration of 8/1/2019 by the Gaon Bura and related of the SDO can be relied upon to decide whether the claim of the contract claim over the disputed lands by the applicant and the respondent. That is why, my lord, for this particular para, my lord, I am here to revision, here for seeking revision.
Consent is withdrawn.
On the grounded, my lord, the order that the 26/9/2019 was set aside. Now the learned trial court has set aside the particular order. But despite of that, the particular order which already been set aside, but despite of that, he extract some portion where the allegation is there that some of the Gaon Bura has withdrawn. So, my lord, despite of that, what my contention is that this has never been questioned and this has never been challenged, even at the time of the appeal also, man. In the appeal also, nobody has raised. Therefore, my contention is that since the order that the 21/7/2019 has been used for the various in the litigation, this has till today, this order is unchallenged. Therefore, the order on the basis of this suspicion,
No, you see,
this cannot be taken back for the de novo trial.
Mr. Modi, with what I have understood of this, this traditional litigation
Madam.
is that a memorandum is not required to be made for any proceedings. Correct? Am I right or am I wrong? In course of a customary court procedures, no memorandum is made either of the evidence or of any pleadings.
Madam.
Correct? Now, something has happened in that meeting, whether there was a challenge or not, it's not documented. The minutes are not there. And the civil court has arrived at the finding that the signatories to this 21/7/2019 had withdrawn their consent. Now, whether there is a challenge or not, how do I examine that? If you don't have a memorandum prepared, it's a customary court, people are not expected to know legal jargons and legal manner of procedures.
Madam.
You-
Exactly,
you
madam.
were-
That is,
You were making a submission that 21/7 has attained finality. And we find that in this 21/7, there's a specific finding of the civil court that the consent was withdrawn. Now, if that consent,
exactly, my lord. That is the same point what I'm raising before this honorable court.
no, but
Before
you tell us, you tell us, you come to your cause title of this appeal.
In term of the appeal,
In this appeal, your cause title, there are only 2 respondents. And how many people have withdrawn their consent? How can we decide this matter without in their absence? Some people say that our consent was withdrawn. Now you have challenged that finding. Now, how do we examine that whether this is right or wrong? Those affected persons whose signatures you now dispute, they are not before
no,
us.
my lord. For that, my lord, I am ready to give demonstrate, my lord. My lord, so far making them respondent 2 person is only the, my lord, the secretary and the president of welfare, my lord. They have the
No, this is
form
not a- this is not
called
a-
the higher habeas,
This is not a representative capacity appeal.
my lord. And what I am trying to demonstrate, my lord, that the order which was passed on 2019 was decided that was come to the conclusion after taking all the evidence and all participate by the villagers, which is clearly, my lord, written, and my lord will find that numbers of as many as 97% were attended the meeting, and thereby, my lord, this conclusion came, my lord. So this is the other group who is appear since 2019 that this land so-called the particular area should be declared as a community land. Therefore, my contention is that I am the person who occupied the land, 147,000 square meter has been under my possession since 2004, and undisputedly this has been decided. Now the parties are trying to include my land within their community land. These respondents are trying to declare the area as a community land, my lord. Therefore, my lord, if the community land is not included, the land which I have already possessed, my lord, there is no question at all. But the thing is that despite of the customary court has decided in my favor, but without challenging that particular order, they have taken another decision that no person will occupy the individual for individual purpose in that proposed village community land. So, my lord, in this regard, I have already appeared this honorable court by the WPC number 91, whereby my lord will find my lord may kindly come to the page number 96.
Page number
95, my lord.
95.
95. Yeah, my lord, this honorable high court has already taken the cognizance pertaining to this particular order, my lord.
What has happened
Page,
thereafter?
page 95, my lord.
I have read this order. What is the
My lord.
fallout of this order?
My
What
lord,
happened thereafter?
while this order is clearly said that whether as per the decision of 21/7, 2019, this has been included or not. So what was the duty of the SDO? The SDO was entrusted to find out that whether this land is included within the proposed community land or not. But despite of that, my lord, the SDO has passed the order in such a way that the title, as if the title has been decided, that I have been, my lord, kicked out from the area by saying that you have no right to over
This IA is in which case? Interlocutory application, page 93, is in connection with which page? Which case?
My lord, pertaining to this case, my lord, same area, village community proposed.
This is an IA, interlocutory application,
My-
page 93. IA is in which case?
In fact, my lord, this was the WPC number 91, my lord.
Hmm?
So, my lord, there was something clerical mistake in the
WPC
pertaining to
91.
while passing this order.
This is in.
This
WPC
was
91.
in the WPC number 91, my lord.
There was a revision. What has happened to that revision?
Then thereafter, my lord, the revision 46. That the revision 46 says that since the matter pertaining to the dispute,
We don't find any merit in your matter. You see, I'll tell you why. You are showing us this IA Civil 2 of 2022. Correct?
my lord.
Now come to the finding of the civil court at. It has made elaborate discussion on this order.
My lord, civil court order
Paragraph-
in
Paragraph 7, 102. It is arrived at a finding and it is in this connection that this office, that this Gamburas or these persons withdrew their signature. Para 7, there is a
my
finding.
lord,
Para 7 is the finding,
para 7 in page number, my lord.
102.
Correct, my lord. This has been, my lord, this was the finding of, on that case. Now, at this stage, my lord, the order 26/9/2022 has been set aside, my lord. That I am agreed with that, my lord. I am not agreed against that. The order passed by the SDO has been, my lord, set aside. That was my challenge. At the same time, the subsequent order, in the subsequent order passed by the village authority of the 16/10/2022 was also set aside, my lord. And I am agreed with that, my lord. I am not agreed against the
Which order was set aside?
set aside.
Which order was set aside?
Order passed by the deputy, order passed by the SDO on 26/9/2022 and the order 16/10/2022 passed by the village authority was set aside, my lord. Now my agreed portion is only that while these two order was set aside, the order that the 21/7/2019 was also set aside. As a result, my lord, now the
That we have heard. That is why we are asking that question. That you have already said and we have heard it.
my
This, the other settlement was there. You are taking us back to square one where we started. This settlement which was made, the persons who were signatories withdrew their signature. Please don't come back to the same position. We have traveled from there to another far ahead. This signature on that settlement was withdrawn. And on that, you are referring to few paragraphs and I am showing you the finding of the civil judge on those paragraphs. So we have traveled beyond these two orders which were set aside and the third order, earlier settlement set aside. We have traveled beyond that. Don't come back to that. You please, you sustain the challenge to the order that how can a settlement be, shall remain if the signatories to that settlement have withdrawn?
my lord, so far, my lord, the pertaining to the settlement of withdrawn is, my lord, that was also not accurate and that was already
This is-
been, that
this-
particular order has been set aside by
For
the
that, we are
civil
not
judge.
getting this revision. Correct. See, people have withdrawn their signatures, that remains unchallenged. And
Other-
in this revision, we can't travel beyond the brief.
Exactly, my lord. Otherwise,
that-
my lord,
so
so far this withdrawn is concerned, my lord. If any GB, Gaon Bura and any other party has been withdrawn from the, my lord, case, then this should have been, my lord, there should have been appeal, my lord. This is only the contention made
is
by
an-
the,
an
contention made
agreement.
by the SDO, my lord.
We don't know you.
Otherwise, my lord, I annexed the document which is showing that that was also not true.
Please
My lord,
forget everything.
kindly
Please
come,
forget these things. We are asking you a question.
my lord.
In a settlement, somebody comes and says that the settlement was fraudulent. I was not correctly apprised. I have withdrawn my signature. But that was never challenged. You have accepted that.
At the same time, my lord, my submission is that the document is here before the lordship that showing that those Gaon Buras, particular person, that they came to the, before the authority saying that they are not agreed against that. They have not been participated in this decision, my lord. Not been in, my lord, withdrawing of their signature, my lord.
Where is that?
And pertaining to this,
Where
my
is-
lord,
where is
I have
that?
to inform this honorable court that the police has investigated whether matter pertaining to withdrawals of the Gaon Bura after the subsequent that has been done or not.
Police does not have power to investigate. This is not a cognizable
Oh,
offense.
of course, my lord, but that already have been done. So, my lord, may kindly come to page number 17.
That is a dustbin.
Page number 70, my lord.
That is a trash.
It-
Worth going to a dustbin.
In my, and, my lord, in the present, this, case, I have annexed that the police said that show part pertaining to whether they has withdrawn or not, this person is concerned, my lord. That the verification, police verification
Don't-
was also done.
Don't,
Because that is,
don't take
that
us
is the
to-
allegation of the forgery, man.
don't take us to that aspect. You see, you will have to show that cancellation of an agreement or withdrawal of signature of an agreement is something which is which is permissible to be investigated by a police. What offense is there? Why police will come in? If they poke their nose in such a matter, we can only think that the appropriate authority will start a disciplinary proceeding against them. How can police go and search whether this signature is there or not? Let us say in your matter, one of the lawyer comes and says that, this is the signature in the Vakalatnama is not mine. Unless we draw up a proceeding under 195 and then ask the police to register a case, police just can't come in the courtroom and then search for the signature, get it verified, and then say that no, we have investigated the matter. Who has asked them to investigate? Which FIR was lodged?
Exactly, my lord.
Power.
That is the same point I am trying to demonstrate before the lordship. What I am trying to demonstrate is that whatsoever the decision was passed, decision was signed by the numbers of the people as much as 97%. So even if anyone say that I am withdrawing from the decision, that should not be, my lord, accepted. Because rightly or wrongly, after the prolonged discussion, the decision has been taken into drawn. Decision was drawn on 21/7/2019, whereby, my lord, the decision was held in my favor. Therefore, my lord, since that village authority has already decided, even if any of the Gaonbura or any of the signatories come back and saying that I am not accepted that, no, he cannot take back such a decision. Therefore, that decision can be corrected through the appeal, my lord. One should be appealed. Yes, that if it is established that then the respondent could have a good appeal, good case to establish that they have withdrawn or not. But until and unless that procedure was not done, therefore,
Come back to
the
come back to
order
the-
passed by the customary
come back to the
court should be,
decision.
my lord,
Come back to the
EPA.
decision of 1610.
my lord.
Where is that? Which page? 1610.
16, my lord,
Mhm.
1610 in page number 42. It is start from page number 42. So my submission is that since already decided, this is the second, my lord. In fact, this is verbatim, my lord, res judicata, because the village level already decided without challenging the earlier
Okay, where is
decision
the-
how
where is-
this can
Where
go.
is the second order?
My lord,
Second order and the challenge, where is that?
and the other order in the challenge is, my lord, start from page number 40, 39 to this one 40, 41, my lord. This is the order passed by the SDO,
39
my lord.
to 41.
So what my contention was that
Just a
SDO
moment,
was,
just a moment. Let me read that.
So my lord, my backbone point in this civil division is the order which I have challenged that has been set aside, my. Thereafter, my lord, the order which has not been challenged is, my lord, decided to take up de novo, my lord. Since the appeal has already disposed of, if the de novo was to be taken up, my lord, at the time of while pending the appeal, my lord, this de novo should have been, my lord, started. Secondly, my lord, I am in such a position that despite of, my lord, the customary order in my favor, which has never been challenged. So, my lord, why that de novo trial should be, my lord, conducted against that particular order, my lord. The order of the learned trial is, my lord, very clear that the de novo shall be trial on that basis, because there is something suspected, my lord. Therefore, this is clear case wherein this de novo trial should not have been, my lord, initiated in respect of the order dated 21/7/2019. So at this instance, my lord,
This,
I'd like to
this, what you call this adjudication by the original authority by 26/9/2022 and 16/10/2022 is the initiated, Parvana is available? How is it initiated? Who are the parties?
this 26/9/22 and 16/10/22, my lord, these were initiated on the basis of the, my lord, order passed in the IA number that we have already read out in page number, my lord, WPC number 91, whereby this honorable court said that since the matter pertaining to the disputed facts, therefore this may be settled, and the SDO was entrusted to find out whether the land which under my possession undisputedly is included within the area or not. Now, wanting to inform this honorable court is that these respondents are the group consisting of the various areas trying to establish a village community land, including that particular area called Tatu Bhapa. So my contention is only that whatsoever your initiation of the proposed for village community land started since 2019, whereas my land is under my occupation since 2004, that already been declared by the villages of this concerned area, particularly these villagers of the UPR. The land is fall within this UPR jurisdiction. Now they are trying to include that land. So I am agreed only that until and unless you have not participated, what this community, village community in the name and style of the Higher Heavy Catchment Welfare Committee. This was established in 2014 after a decade. Therefore, now I have been brought back in such a situation that I have to file another title suit, my lord, to establish that as per the order before this.
You'll have to. You'll have to, you have no other
In
alternative.
such situation, my lord, there is a possibility.
You see,
Since I have the order with me.
you
Since
see,
the
I'll
order
tell you,
is in my
I'll tell you, there's nothing in your favor. Everything is hopelessly pitted against you. I'll tell you why. You are referring to Annexure E, which is deed of settlement of 21/7/2019.
My lord.
You see, I have no business to tell you why I'm passing an order, but I'm telling you because since you've been arguing so, with some conviction, that's why we are telling you. I had no business to tell you, but I am still telling you. You see, come to Annexure E, which is at page 60. It's a meeting decision of 21/7/2019. this is a
60.
dispute. This is a dispute between UPia villagers and Gamar Takar. Okay, UPia
Exactly.
villagers. We don't know who are UPia villagers. We don't know. I personally have no knowledge. Now come to this 26 September 2022, which is page 39. Here the respondent is Tuna Gumesh Tara and Gyamar Bharat is the petitioner. Now, this relates to inclusion in the community land. What is a community land? For which community it is being sought, we don't know. The name of the community apparently is not there in this order. It merely says Hayar Habia Catchment Area Welfare Committee.
My lord.
Whether this is UPia villages, we don't know. Correct. Now
Exactly.
come to this minutes of 16/10/2022.
Page 42.
Yes.
My lord.
Now, this is legacy right between over Totup Haba and its adjoining areas. Now, which is that area, we don't know.
This Totubapa is the particular area in
No,
21/7/9.
wherever it is, wherever it is. But that is not within the settlement of that UPia villager. And the question is that UPia villager is the party and you have taken the consent of 4 or 5 Gaumburas. This shows that they are authorized to represent all the villagers. There is nothing here. You take one order from some place, second order from some place, third order from some place, and then try to weave a very good fabric.
My lord, I have annexed those who were the signatory in that decision, my lord. So exactly, my lord, now, my lord.
In the absence, you are doing a second litigation and third litigation.
Here, my lord.
No,
Now,
I'm sorry, we're dismissing
no, my
it.
lord, I am to clarify
You
this
go
line.
file a suit.
Clarify this line only, that, my lord. Now, this proposed community land is, my lord, in page number 42, showing so mass of the area called, my lord, the Tatubhapa and adjoining area. So po yoka kala potar kala pahar parna tatum so much here, man. Very vast area. So this include my contention is only Tatubhapa is
Understood. This is a land of how many square meters? Land is how much?
my lord, so far this proposed community land,
1,47,000 square meter.
my lord.
You can't be permitted to have that land with by litigation with XYZ, then ABC, and then DEF.
My lord, that is clear. But what my contention is that whatsoever the village of the UPI has
No, you
already
file a
been,
suit,
my
get
lord,
it
in
declared.
decided.
You will have to decide with the in the presence of parties. You can't have an order struck down without those parties being affected parties being here. We are not deciding a representative capacity revision. Third, Mr. Steve Modi, learned counsel for the petitioner. Next, by filing this revision under Article 227 of the Constitution of India, read with Section 115 CPC, the petitioner has assailed the order dated 21/8/2024, passed by the learned civil judge, senior division, UPI, in appeal number 1 of 2023. Full stop. Next, by the said impugn order, while interfering with While partially allowing the appeal, in respect of order dated 16/10/2022 and 21/7/2019, passed by the customary court and thereby set aside the said two orders dated 16/10/2022, 21/7/2019, as well as order dated 26/10/2022, passed by the sub-divisional officer, Doimuk, directed that the case be proceeded de novo. Next paragraph. The learned counsel for the petitioner is that that the petitioners are not aggrieved by the interference with the order dated 16/10/2022, passed by the customary court, or by the order dated, or by interference with the order dated 26/10/2022, passed by the sub-divisional officer, Doimuk, the petitioner is aggrieved by interference with the settlement order dated 21/7/2019, on the ground that the said settlement order has attained finality. Next paragraph. The learned counsel for the petitioner has submitted that the said settlement dated 21/7/2019 was passed in a proceeding before the customary court, unless an appeal is filed against the said order, the learned civil judge, Senior Division UPIA, had no jurisdiction, right, or authority to interfere with the said settlement order dated 21/7/2019, which was not the subject matter of determination in appeal in the proceedings of Civil Appeal number 1 of 2023. Full stop. We have examined the materials available on record. Full stop. It is observed that that as per the contents of the deed of case settlement, which was held in a meeting held on 21/7/2019, the said meeting was held to settle the long pending cases between UPIA villagers on one side and the petitioner, namely Sri Gyamar, Gyamar Bharat, Elias Takar, Takar, regarding land dispute at TOTUP, HAPA, HFA, area at measuring 1,47,000 square meter located at about 17 TO2 20 km from Doimuk range located at -27 degree. This you understand degree, na? Small zero. 27 degree 11 colon 00, then double
Longitude.
what you call apostrophe, double apostrophe, and then 6 again double apostrophe towards north, and 93 degree 43 colon 11 double apostrophe towards the east, which falls under the UPA village jurisdiction. Full stop. The house present in the meeting had taken note of the projection that maximum majorities of UPA villagers had already put their signature in the NOC in favor of the petitioner's ownership of the developed area in TOTUP, TOTUP, HAPA, HAPA. And he was in possession since 2004. And accordingly, it was held that it was approved that he is the owner of the said area and is eligible to obtain LPC. Full stop. The said settlement was signed by four village authorities within bracket Gambura and 9 members of the parties present including the petitioner. And the same was countersigned by an executive magistrate on 23/7/2019. Next para. The order of the next, the order of the subdivisional officer dated 26/9/2022, on receipt of remand of the matter pursuant to order of this court dated 26/8/2022, asked in IA Civil 2 of 2022. Kumar, took into consideration the settlement deed dated 21/7/2019, considered the projection that the Gaumburas who had declared the ownership of 1,47,000 square meter of land at Totok TOTUP HAPA HAPA in favor of the petitioner had withdrawn their signatures, citing that they had been misled and cheated by the petitioner, the subdivision officer posed a question that whether only 4 persons, though they are Gambura of the village, had the authority to give ownership of the land to any individual which is not owned by them. Full stop. Accordingly, the same was said decision was not accepted, and it was held that the petitioner could not produce any tangible evidence which could prove the matter beyond all reasonable doubt, that the land in dispute is his private land, and cited the reason that as the petitioner has not inherited the land from his ancestors, and neither any actual landowner has gifted him this land, it was held that the petitioner, that the claim of the petitioner that 1,47,000 square meter of land at Totok HAPA TOTUP HAPA is his private land could not be established. Full stop. Accordingly, the matter was disposed of. Full stop. Stop. It is also noted that amongst the persons who were present, who were shown to be present in the order dated 26/9/2022, there are 3 out of 4 Gamburas whose presence is recorded. Who's told? Out of 4 Gambras whose signature appear in the deed of case settlement dated 21/7/2019. Out of 4, 3 are present. Who's told? So out of the 9 persons whose 9 parties whose presence is recorded in the deed of case settlement dated 21/7/2019. On the Mr. Modi, only 2 persons are present. Correct. You and one Garmar Peter.
My lord,
No others are there.
no other one.
Page 39, I am just transposing page, juxtaposing page number 62 with 39. You are there, Garmar Bharat, Garmar Peter.
And there are other 11 members from the,
Others are
Yes.
not there.
yes, others are the JB, this response.
No, I don't know. I'm just juxtaposing page 62 with 39. I'm comparing these 2 pages. Out of signatures in these 2 pages, only you and Peter, the Garmar Peter, they are there. Only 2 of you are there. Out of 9 people, only 2 of the parties are found represented in the order dated 26/9/2022. In the meeting of minutes held on 16, next para, in the meeting of minutes, minutes of meeting held on 16/10/2022, under the chairmanship of one Golo, GOLLO, Nikia, NIKIA, GPC, 2/6, Tigdo, TIGDO, Gram Panchayat segment. It is noted that the said meeting was called regarding Totuk Hapa areas basing on the genealogy story who settled there in past. And after discussion, it was held that the Tana TANA, Teri TERI, Teshi TESHI, and YAB, Yab clans have gradually migrated to the plain region and settled at the present homesteads. But they exercise their complete control and authority over these areas. And accordingly, the it was declared that the authorities concerned must recognize and declare Totu Hapa, now the spelling changes, TOTUP HAPPA, and its adjoining areas as village community forest land areas through official gazetteers, GAZETTEERS, notification in the larger interest of preserving and conserving the flora, fauna, and catchment areas for sources of drinking water of Upia, Tigdo, TIGDO, Borum, BORUM, Sud, HOOD, Midpu, MIDPU, Doimuk, Nirjuli, and Naharlagun. Full stop. Next paragraph. In light of the decision taken in the minutes of meeting dated 16/10/2022, on having observed that the land is declared to be of 4 different clans and the meeting attended by 27 attendees have agreed to declare the concerned land and its adjoining areas as village community forest land. Court is of the considered opinion that the decision of the deed of case settlement dated 21/7/2019 order dated 26/9/2022 passed by the subdivisional officer, Papumpare district, Doimuk, and minutes of meeting dated 16/10/2022 which are set aside by the learned civil judge within bracket senior division, bracket close UPR, is not liable to be interfered with, and the case is required to be proceeded de novo, however, in the presence of all the concerned parties whose interests are reflected in the said orders. Including the concerned including all other concerned who are proper and necessary parties in such adjudication. Full stop. In view of the revisions assigned, this revision is found without any merit and is dismissed at the motion stage without issuance of notice on the respondents.
My lord, one line we added, my lord. My lord, the petitioner never challenged this order dated 26/6/22 and the 10/6
said that.
before,
We
yes.
have already said that.
What?
21/7, we have said that. We have given one paragraph for that.
I have only
There was no challenge.
I have not challenged, yes.
Then I have noted. In the second paragraph only, we have noted that.
Oh,
Lordship, this is a pre-arrest bail, anticipatory bail application. Lordship, the case is of civil nature. First of all, I would like to
Where is the FIR?
FIR is page number 14. As per the FIR, Lordship, kindly see. Allegation was there against me in a paragraph 3. 19 lakhs 59,000. No doubt, Lordship, admittedly, this is a contractual amount.
Oh, no, we grant him bail. This is a civil dispute.
Yes.
Lordship,
There is an agreement.
Lordship,
clear.
where Lordship, there are 2% Lordship, and Lordship, it is that Lordship, case study may be called for Lordship. Or
We'll give
after,
him an interim. We'll give an interim then.
then in that case, he may be directed to appear before the
Yes,
IO
yes,
case
we'll do
statement.
that. Mr. T. Tapak Lamed, counsel for the petitioner. And also heard is
L. Hage.
L.
L. Hage.
L.
L. Hage, learned ABP appearing for the state. Next paragraph. The petitioner who is apprehending arrest in connection with Itanagar PS case number 89 of 2024 under section 120 capital B oblique 420 of the IPC corresponding to GR case number 585 oblique 2024 has prayed for pre-arrest bail under section 482 of BNSS. Next, part, let the case diary be produced on when
26 Lordship. 26 Lordship.
26. 26/9/2024. Next paragraph. The learned counsel for the petitioner had paid for interim bail, comma, which is approved by the learned ADP. Next paragraph, on a consideration that the allegations made in the FIR appears to be a financial transaction between two sides. The court is inclined to grant interim bail to the petitioner, namely Dheeraj Pao, on his furnishing a bail bond of by providing that in the event of his arrest in connection with Itanagar PS case number 89 of 2024, are you right? It is 89. Because I am reading 90.
It is 89.
Look at page 14. I am reading 90.
Page 14.
Zagi, what is that?
90 is 90 2024.
It is 90.
90 Lordship.
90.
Lordship.
Then No, but here in page 11, it is 89. Zaki, what is right?
Yes, actually, it should be 90 lordship,
No,
90.
look at page 11. In the column,
Yeah.
it is
Yes, Lord.
89,
89.
FIR number 89.
89 is
So
correct.
which is right?
Yes.
89.
This is right.
Yes.
89 so and so. You just say 89 within bracket. The FIR number given in the form FORM, form of the FIR, comma, however, written as as Itanagar PS case number 90/24. At the body of the FIR, which is signed by the officer in charge, Itanagar Police Station. Comma, the petition shall be released on bail or is furnishing a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting officer. Next para. The interim bail is granted on the following conditions. And these are standard terms which is you will find with these two stenographers. Take it from them. One of the condition would be that the petitioner shall appear before the IO within a period of 7 days from the date of the order. Failing which, the interim protection so granted to the petitioner shall send lapse by a flux of time. Next para, list on 26/9/2024. 7 days to appear before the IO. Yes.
Yes, Lordship, I filed this application under 439 subsection 2 or review section of 482 of BNS Union. Praying to set aside the bail order passed by the session court by order 13/8/2024, Your Honor. Being aggrieved with the bail granted to the accused Yamik Dulam Darang, respondent number 2 by the district and session court Pasidar by order dated 13/8/2024. The petitioner has filed his application under section 439 subsection 2, reduce section 482 of BNS for cancellation of the value, Your Lordship. The respondent number 2, Yamik Dulam Darang, has acted negligently, did not follow the procedure, tried to mislead and the investigation agency by way of perjury and also tried to influence the applicant, Your Honor. The custodial interrogation is.
Since bail has already been granted, we are issuing a notice.
Your Lordship, the complaint respondent number 2 is the president of Vase, woman.
No, whoever she is, I would like to issue notice. I can't cancel bail like that without hearing others, the affected party.
I'm for resolution 1, 3, 4, and 5.
Third, miss, your name?
O Bingep.
O
Bingep.
Bingep, BINGGEP.
Yes.
Learned counsel for the petitioner. Also heard Mr.
G. Tador.
G. Tagore, APP, Tador, learned APP appearing for the state respondent numbers 1 and 3, 1, 3, 4,
1, 3, and 4.
4, 5 also, I think.
5
It is an IO,
is by name.
but we can't help
Yes,
it.
IO.
Because under the requirement, the informant is to be given.
Obviously, it's gotta be the.
1, 2, 3, and 4. Next para. As we notice that the respondent number 5 is the IO of the concerned case, comma. We directly run an APP to also appear for the respondent number 5. Though he is impleted by name. Next para. By filing this application under section 439 within bracket 2, now new provision is 439(2).
Yes, Lord.
Okay, 439(2) of the BNSS. Comma, read with section 482 of BNSS. Comma, the petitioner is the mother of the deceased. Has prayed for cancellation of bail granted to the respondent number 2 by order dated 13/8/2024. Passed by the learned Sessions Judge, comma, East Siang District, comma, Pasighat. Where is that order? What is the case number? In connection with AB number 32 of 2024, in connection with PSG PS case number 94 of 2024, under section 103 within bracket 1, bracket closed, oblique 3 within bracket 5 of BNS 2023. Next paragraph. Issue notice returnable on returnable 30/9/2024. Can you serve it by the police by that date to the concerned police station? Can it be served
Yes, we can.
on 30?
Notice.
Post of the petitioner shall take steps for service of notice from respondent number 3. Sorry, 2 by registered post with AD. Post of in addition, return of notice along with the copy of this criminal petition be provided to the learned APP would make an attempt to, would make serve the notice on the respondent number 2 through the jurisdictional policy. Next paragraph. It is made clear that the pendency of this application, this criminal petition shall not constitute as a bar for the learned sessions judge, East Siang District, Pasigat, to decide the AB number 32 of 2024 on its rate without being influenced by the notice issued in this criminal petition. Next para, the learned DPP shall, no, you just say that the registry shall transmit downloaded copy of this order to the learned sessions judge, East Siang District, Pasigat, to bring this order to the notice of the said learned court. That would proceed. Bail application would proceed, and we're just issuing a notice in this interim bail granted. What is the next date of that? What is the next date before the sessions court?
Your lordship, no idea.
Huh?
No idea.
But you're challenging the order, you should know.
The next date, no idea.
Because if supposing the matter is in 1 or 2 days, then there's no point in sending it. I'll just take it from the registry. If the matter is given in a short date, then we'll list it again. We may not pass the order. If it is in 1 or 2 days, then we'll have to wait of the outcome. Because it is only the interim bail. So please come back at 2. We'll try to find out from the registry. Please be here at 2 o'clock. The order may be already taking note of the next date before the sessions court. At 2 o'clock, please be there.
All right.
Final order.
Your lordship, the case is not charge sheeted.
Huh?
Not charge sheeted.
No. The order is a final order, not an interim order. I misread it as an interim bail. So the order will be there. We have issued the notice. You need not be here at 2 because I had misread the order. I thought it was an interim bail. Correct? That's why I called this recorder and checked it. Notice will be there. It is a final bail order. I misread it as an interim bail.
It's-
I understand. So that order will stand. The order which I have dictated will stand. No, not by registry. This is a cancellation application. It goes by registered post. And in addition, we are sending it through the jurisdiction police so that it will be faster. Next.
Highly applies.
May it please your lordship.
Yes.
Lordship, I'm extremely sorry. Just a few minutes back, when I was going through the petition, I found that I have left out one annexure column. Rest of the petitions is, there is no any issue. So I may be allowed to correct it. Today itself, I'll collect before the registry.
Okay. The learned counsel for the Mr. A. Bhattacharya, counsel for the petitioner, submits that annexure has been left out, and he seeks permission to include the said annexure.
This column I have left
Mr.
out. Enter in the column of the index column.
And to enter the same in the index column. Full stop. Mr. M. Katul and a DSGI is present. Come on, let his copy be also corrected. Full stop. You want to do it at 2?
So it can be done. I'll correct itself today.
Matlab, Monday, Tuesday.
Or your lordship on Monday.
Matlab,
Monday.
Tuesday, Matlab. Monday I'll be Matlab, having personal
You'll be out of the session.
Tuesday, 24.
List on Tuesday, make it
Oblige.
24.
24.
List on.
Lordship,
Yes.
subject matter of this writ petition is illegal execution of road project, Pradhan Mantri Gram Sadak Yojana project in violation of the DPR. So
Yes, that's
matter
fine.
may be admitted and a rule may be issued at this stage. And matter may be posted for hearing.
Just a moment. Your writ petition would not be maintainable. What you are essentially asking is adjudication of a purely civil dispute. You say that the PMGSY land,
Yes.
the road which was being constructed, entered into your land and damaged, and you are seeking compensation.
Lordship.
For damages in a writ petition, how do I make the assessment? Please tell me. Whether it is 1 square feet, what is the area of what is the cost of 1 square feet? What is the damages? How do I make the calculation?
One more submission, Lordship. In the same, in the connected matter, which has been disposed in the writ petition, there was an inquiry by the SP.
That inquiry we can't
There-
do.
there was a-
Fact finding inquiry we can't
Yes,
do in a
fact-
writ petition.
Fact finding inquiry
We can't do.
conducted by the, no, Lordship, that has been already done.
No, we will undo that.
Yes, already
It can't
done.
be.
And as per the report of the.
You see
SP,
that,
As per the
order,
report,
please understand,
yes,
act which has been done in derogation of the well-established legal principles cannot be a binding precedent. You want us to adjudicate claim of damages in a writ petition? It's a factual inquiry.
Lordship, kindly see this this petition is against the government, first of all. Against the government.
Please
When-
tell me
when
about
there
the
is a-
principle of
When,
damages.
when there is a violation of.
Please tell me about the principle of damages.
Lordship,
Are you aware of the principles?
with regard to DPR, Lordship, DPR is in the issue here, Lordship.
Oh, forget the DPR.
When detailed project report, as per the this, department concerns, when the department was not maintaining the DPR, executing the road from the private land, that is the issue here. When illegally government is executing the road from private land. That is the case. That is
Continue
why,
your argument. I am hearing you.
yeah, that is why matter may be fixed for hearing,
I
Lordship.
am hearing you. Please start.
Lordship, particular that may be fixed. I have to be ready, Lordship. Any date may be fixed.
When court
Yes.
puts a question, then you are not
And I
ready.
may be allowed to vote on record of that already disposed in the matter that
You do
one,
whatever you want. If
one,
I'm adjourning it,
one,
you do whatever you want.
one additional affidavit in the next.
You forget
in the
everything.
conducted.
You forget everything. I'm asking you one simple question, you say that you are not prepared. Please explain me the principle of damages. How damages are calculated. Are you
Not-
aware of the
not-
theories
Not exactly,
which come
Lord.
in for assessment of damages?
Not exactly, Lordship. Kindly see. My prayer is, Lordship.
You forget
Not-
everything. I'm
My-
telling you time and again. This is the third
Not
time I'm
exactly,
telling
not
you.
exactly, Lordship, damages. My
Please
prayer.
tell me, my
Yes.
question, please answer this question. Don't dodge it.
Yes,
It's something I dislike.
yes,
I'm asking you a question in the context of principles of damages.
yes.
Are you aware of the theories which apply in calculation of damages? Are you aware of that? Number two, in connection with the principles of damages,
Yes.
please tell me, you see, whether it requires a calculation and whether it is a simple calculation or a complex calculation.
Lordship, first of all, my petition is not a damages suit. This is a writ petition, Lordship. Because my prayer number one is to set aside.
I'm
to
sorry.
Set aside. Lordship.
I'm sorry, I'm wasting my time.
Yes.
If I can't make this
Yes,
make you
matter may be
understand,
fixed for hearing, Lordship.
I am hearing it. For motion, I have
That is-
heard it for
that
one,
is- that is-
1 hour. If you are in my court, please understand one thing very clearly.
My
Whether
prayer
it is a
number-
motion stage, whether it is an admission stage,
This is
whether it is an order
admission-
stage, please let me complete.
Yes, Lord.
Don't make me lose my temper. It's not that I don't know how to shout, but I have a belief that I should rise with a smiling face and go home in a bed in a smiling face. That is why I crack jokes. I keep my mood lighter. It's not that I don't know how to be angry. Don't push me to a point where I say something which is derogatory towards you. Please don't make me do it. I know my job well. I know how to control the proceedings of the court. And thirdly, when it comes to principles of damages, please understand that when I'm asking you this question, I thoroughly know this subject.
Lordship, I am not praying for damages in this petition, Lordship. That has
You
to
are
be
asking for
understood.
compensation.
I am not praying for damages.
You see, I'll reject your prayer for adjournment and dismiss it right now.
My prayer is to
Please,
set
if you
aside
don't,
the
if you
illegal
don't,
execution, Lordship.
if you don't make submissions to the query I am making, please be aware that I will be dismissing your writ petition even without hearing in limine. And I know how to write the order. I'm asking you a question. Please make a response straight and simple. Don't dodge that question. If you are aware, tell me that you are aware. If you are not aware, tell us that you are not aware and take an adjournment. But don't ever try to dodge the question which is the court is asking you.
I may be allowed to file additional affidavit, Lordship. In any case. So
I'll
that
just
matter
write
will
the
be fixed for hearing.
Heard. Mr. T. Tapak, learned counsel for the petitioner. Also heard Mr. G. Tarak, learned standing counsel for the RWD, Mr. D. Kamduk, learned CGC, as well as Ms.
My lord, I am extending counsel, my lord.
Standing counsel for
Land management. my lord.
land management.
Yes.
Oh, okay, and
Your Lordship, I'm appearing for
no, I forgot the name.
peace.
P. Sangita, learned government advocate appearing for the concerned government respondent. Next paragraph. On a query of the court that if in construction of a road under PM GSY scheme, assuming the land of the petitioner has been encroached wrongfully, whether the whether the writ court should entertain a claim for damages, comma, which is essentially a dispute to be adjudicated before a civil court, comma, the learned counsel for the petitioner has submitted that in an earlier proceedings of similar nature, comma, this court had ordered an inquiry in another petition. Which petition? Which writ petition?
Exactly, this number I have forgotten, but
Okay.
that was the.
Ordered. Full stop. So they said submission, comma, the next query of the court is whether the writ court is empowered to bypass a civil court's jurisdiction to award damages, to have an inquiry made and to order compensation would be in accordance with the law, and whether even if the earlier decision of the court is has permitted that, comma, whether it would constitute a binding precedent. Full stop. On the said query, the learned counsel for the petitioner seeks an adjournment. Here is allowed. Let the matter be listed after the ensuing long vacation. Yes,
Wait, please, Lordship. Lordship, the petitioner is the LLP registered under the MSME Act.
non-payment of contractual dues. Yes.
Lordship.
My lord, this case, no cause of action against the state respondent, since the contractors who execute the PMGIS road, on behalf of them, the bill was, order was placed. And bill was also raised against the contractor, not against the state. From the document itself, it reveals.
Okay, but what is the law in this regard? If a
may.
subcontractor,
If I may, Lordship. Page 18 is the supplier.
page,
18, my lord. Annexure 3 of my petition. That is a typed copy. If I may read to the terms that they have set for the supply order. Raj, page 18, annexure
page
3.
18, yes,
Yes, this is the typed copy of the supply order.
yes.
If I may read the terms, my lord. in the first page it says, as per discussion held on so and so date at the office, have accepted your commercial terms and conditions on supply of bitumen hot mix material for credit period of 1 month from the date and supply of material at site towards lump sum advance payment. Then they say that these are the suppliers to whom you have to supply the product. In the next very page, my lord, in the page number 18, they set out the terms and conditions for this supply order. The first being, the material shall be supplied at site and proper challan invoice bill should be produced as per direction of the engineer in charge. The defective material should be replaced without any conditions. And the third says, the payment shall be made in 1 month time as and when contractor payment was made. Now, my lord, the contractor payments are made. My reasoning of filing this writ petition for this cause was violation of Article 14. The equality they did not show towards my supplier. They have paid the payment to the contractors, but they are on the other hand not paying bills of the supply that was done through this supply order. Pursuant to which we have pursued with the private suppliers also, but they are, my lord, I have made them a party in this writ petition also. All these years, 3 years, they are hard to find towards this court also. I have filed my newspaper publications for them to appear before this court. They have not appeared. After 2 years of filing this writ petition, they could invoke a response, and this affidavit was filed last week. In this affidavit also, they have not been categorically denying my allegation that I am not eligible for payments. Only they are shifting the burden from them towards the private respondents. My lord, what has happened here is that we would have not made this supply unless the government would have not given us this supply order. They stood as surety, so we supplied the order. Now they have to be a model businessman as in terms of the judgments, my lord. If they come and give us a supply order and
There's nothing called model businessman.
my lord,
Where
what,
did you get that term?
my lord, I have got it in one of the general where they say that the government has to be as model as any other person,
Model employer.
model employer. But again,
But
that
model
does not-
businessman, term is yet to be understood.
my lord. But my lord, if this supply order would have not been there, we would have not supplied this product at the first instance. My lord, and the tune of 72
You
lakhs.
filed
is
an
not-
affidavit?
They
Yes.
filed their affidavit, my lord.
We have filed.
Yes, what is your stand, Mr. Tarak?
If I may, my lord. Running page 59 and 60, they state that the grievances towards the private respondents, and later on they categorically deny all my averments made in the writ petitions.
Mr. Tarak, how do you defend your, this order, page 18?
My lord, this order was issued by the executive engineer in favor, on behalf of all these private parties, the contractors. So bitumen has to be supplied to the contractors, and contractor has to make the payment. And bill is also raised to respective contractors. And I am told that some of the contractor has made some payment also.
But I'm sorry, what you're saying, I can't read in this order, page 18, 19.
Yes. But it's not mentioned, but respective firms' names are given. Firm
But
agency,
you see, the clause number 1, terms and conditions, the material shall be supplied at site and proper challan invoice should be produced as per the direction of so and so.
that work site,
The defective material should be replaced. The payment shall be made. You don't say that it will be paid by the contractor.
it's not mentioned, but it was ordered for the contractors.
No, no. You see, if contractor wants, they will, bitumen is no longer, what you call the, restrictive product. At one point of time, we needed, there was a requirement of bitumen being supplied as a restrictive item.
No, my lord,
That was
various
long back.
PMJ project was awarded to these contractors
No,
who are the
understand,
private.
but what, you see, let me tell you, or sorry, ask you in a manner which is understandable. Is bitumen a regulated product?
I have no idea.
It's not a regulated product. It's available in the open market. It is at one point of time when I was small, a school going child. At that point of time, to get bitumen, there was a requirement to have a PWD, what you call, works contract slip. Then go to the supplier. Earlier, it was only the government suppliers like Oil India and all who supplied bitumen. And those bitumen were then sent for, there were few processing units. They were sent there. And from those processing units, you get this. At that time, even paraffin wax was a regulated supply item. It was not available. So a candle factory would have to apply, get a quota, go to the ONGC, Oil India, get that paraffin and then manufacture this candles. Have you seen those days? I don't know. So I had the experience of looking at those things when I was a school-going kid. The background is that I come from a business family, so therefore many of my friends, relatives were involved in this. That's why I know about it. That's number one. Number two, let us say that there is for a purpose requirement of kerosene oil, subsidized kerosene oil is only available in fair price shop. Or for example, you need any item which is a FCI exclusive item, you get it from the FCI, which is this Food Security Act, correct? Now, please tell me, if the government wants a product which is not a restrictive supply, why should the government ask and give a work order that please supply to Y? Y is capable of purchasing it in open market.
My lord,
Why do you need to give an offer?
in the supply order itself says that
No, you
as
supply
per
to him.
discussion held on,
You see,
maybe contractor on a supply.
two of my young colleagues, when I was a lawyer, the client would be outside, I would be in the court and I would say the client, you pay my assisting counsel, that would be enough. So my clients, hardly I got touch of money. It would be paid to my assisting colleagues. And it was a good payment to me. So therefore, when I give a direction to the client to make payment, supposing you don't touch money, you ask that you, whatever payment you want, give it to my junior. Will that be a bad transaction? So the government says you supply bitumen, give it to X. It is paid, given to X. What is wrong in it?
My lord,
X.
supply order, it's but I am also confused. But the bill raised is
No,
not
that-
raised.
No, that you will understand.
They're on the respective contractors or firms for whom they have supplied the bitumens.
Where is that?
That is next page onward, page 20. 22 onwards.
Yes,
Yes, my lord.
Annexure 4 series.
Mr. Singh, he is right.
Yes, my lord. What has happened here was when they gave us this work order and then there was no response from their side, the only remedy that we had with us was to approach them under the MSME Act. That's why the notices that we raised to these people, to this different people who were supplied the goods, were under the MSME Act that 2% interest would be charged. You kindly start paying us back because no response could be got from them. And as a businessman, my lord, we cannot wait for this period for them to condone it and then they start making payments to us. Only when
No,
they were
no,
also.
you have raised bill to the buyer.
Yes, my lord. We
But
have
then-
also, my lord, in page number 50, when this all episode
Page
started.
number?
Page number 50, annexure 7.
50.
We raised a very small bill to the executive engineer also. at that period of time. In the same year, October 2021, page 50, annexure 7, my lord. This was out of the many supplies. One of the supplies we said that, all right, you start giving us this amount, you start disbursing amount. But they did not even accept our bills. At that period, they turned a deaf ear towards us, my lord. And we waited all this while for a period of 6 to 7 months, so that in the hope that the payment when made to the contractor will be making the payment, because they were not giving us any.
No, that means you see
answers.
there is a waiver. You don't acknowledge the government to be the purchaser.
No, my
Once you
lord.
raise bill on somebody else.
My lord, we acknowledge the government to be as a surety between them.
No,
My
that
lord,
can't be.
I read why, because
Even
127 of the Contract Act says consideration for guarantee, my lord.
He is
If
not
I-
a guarantee, never gave a guarantee.
My lord, he gave the guarantee that in 1 month the payment would be made. He said that you supply, in 1 month the payment would be made, as and when the payment shall be made.
Even annexure 8 notice for outstanding bill was issued to the
Madam,
respective
Our
Firms.
activism was that we pursued all the doors. Our active activism was only that we pursued all the doors. Even we knocked the doors of the people we supplied goods to. But my lord, that cannot be hindrance, and that cannot be the reason that they shy away from their payments.
But this can't be a guarantee. A payment shall be made. Within 1 month time, as and when contractor payment was made.
My lord.
The government have released
Why-
payment to
why
the
this supply
contractor.
order, my lord?
Contractor has to pay to them.
My lord, why this supply order was issued? Because these supplies hold a bad reputation in market for not giving us the amount of money. So in the first place, the executive engineer said, all right, the scheme is there, I am there, I'll make the payments. You supply this according to this supply order that I'm producing before you.
But consignment is, the bill is not on them. I'm not satisfied.
My lord, may kindly see the point 3, the payment shall be made in 1 month, as and when the contractor payment shall be made. Those payments have been made, my lord. The contractor payments are already disbursed.
No, but this supply, had you supplied it to the executive engineer, I would have explained, but you
My
supplied
lord,
it
this
to
was the direction of the executive engineer to supply it on site. This was what they made the terms. The first says the materials and supplies at site. My lord, may also take a note of one of the text invoice that we have raised. Starts from page 27, my lords. Starts from page 27. This is the e-invoice that we have raised. My lord may see the consignee, the ship to. The consignee, the ship to, Office of the Executive Engineer, Rural Works Division, Sagal. In our bills, we have made that clear. But only on the directions that was given in the supply order, it was delivered on site. Because the sites were of different location, as my lords will say, in the name of the roads in which and where they are being constructed. So practically that was viable to supply it on the site.
Contract Act, contract. So, Mr. Tarak, we find it that you have given the supply order. You also agree, as per discussion held on so and so in this office, have accepted your commercial terms and conditions for supply of bitumen. Page 18. As per discussion held with you on 20 January 2021, this office have accepted your commercial terms and conditions for supply of bitumen material for credit period of 1 month from the date and supply of material at site towards lump sum advance payment. Please find below details of materials required against each work and it is requested to you to start supplying. So you are saying supply.
My lord, again, now it's difficult on my part. This order is issued by the executive engineer. So then, if I to say, the government, the secretary, the chief engineer, they have no idea about this. The contract was awarded to the various firm for execution of various PMJ's work. And in term amounts cover, now the chief executive engineer with this suppliers, they have a discussion. Maybe all these contractors, they were present. So on behalf of the contractors, on good faith, he has issued this order.
Mr. Tarak, it's very difficult to accept what you are proposing. What you are proposing is very difficult to accept.
Yeah, I'm also facing very difficult to.
I'll tell you why. There's a legal reason. I'm not saying about any other
Yes.
reason, but legal reason. Come to your affidavit in opposition.
Yes.
This is filed by respondent numbers 1, 2, and 3.
That is there.
Correct. By
I
the
have covered
secretary.
it. I cover even,
Yes. But number 3 is the executive
yes.
engineer. So you are filing a common affidavit. You can't say that I am not
That,
Yeah,
that,
you-
that,
Executive
There I
is
am.
not authorized,
Yeah.
so you are trapped here.
that's why I'm.
You're trapped
Facing
here. No, I
difficulties.
think you'll have to pay. You do whatever you want to recover money from.
My lord, otherwise also my submission is that since bill has been raised and notice and issue against these contractors.
No, but
So
you,
if he has to file, a petitioner has to file civil suit against these contractors.
no, but it is your order.
Hmm.
You'll have to do the recovery.
The order was passed on behalf of these contractors.
You'll have to do
For-
the recovery. Blacklist them, they will come to you. You gave the order.
My lord,
Unless, because Mr. Singh is right in saying, unless the state gave an order, he would not have supplied to XYZ
now, as discussed, they might have discussed that, oh, I have, I
in
know.
your office. Discussion was in your office. You come and accept your terms and conditions.
Yes.
You accepted. If the materials for XYZ, why would you accept his terms and conditions? That means you are the principal contractor.
And next, and again, the pay, bills is not against the state,
No, those
executive
things-
engineers,
That is not the
respective
ground.
contractor firms.
That is not the ground on which you are refusing.
Hmm.
Bills are, some of the bills are at you, executive engineer.
The entire payment has been paid to the contractors. They has to
You
pay to
recover-
the
You recover
suppliers.
money. You recover money from them.
My lord, if that is, the case, let me take instruction of these executive engineers.
You can't take now because the affidavit has been filed already. Secretary was,
If possible, I may be allowed to file additional affidavit.
secretary was kind enough to accept it.
This affidavit was
And you
filed
see,
by
come to page 10.
Yes.
Come to page 10. You can't change your affidavit. Come to page 10.
President.
Private respondent number 4567 was awarded contract of so and so. And on good faith, the executive engineer issued a
Yes,
supplied order.
that's why I'm not.
Then
The executive engineer has to be.
That
Clear.
meeting was in good faith.
good faith means, you see.
Discussion was with the supplier and
I
the
was just trying
executive
to find
engineer.
out. You see, that's why I have checked and then now you are trapped by the vicarious liability.
No, man.
Your
Even,
your secretary is filing an affidavit. Vicarious liability sets in and you can't escape that.
yeah. So let me.
No, no, once you have had an affidavit, we can't allow you to do that. It would be very improper. To allow you to change the stand would be very.
No, we will not standard change our stand,
No.
but we have.
You see, tomorrow what is being done, it's not out of our control. But today your affidavit is there. And it is filed by 1, 2, and 3.
Yes.
And secretary is signing it. So he takes the vicarious liability. He admits that you're doing on good faith. So you recover and give money to Mr. Singh. Third, Mr. J. Singh, Leonard, counsel for the petitioner. And Mr. G. Tarak, Leonard, standing counsel for the RWD, representing respondent numbers 1, 2, and 3. So there is no representation from the respondent numbers 5, 6, and 7, although notice was served in a substituted manner. Next para. The learned standing counsel for the RWD has submitted that it is essentially a civil dispute and he questions the maintainability of the petition. It is submitted that the goods within bracket bitumen mix bracket close was supplied to the various contractors and bills were also raised by the petitioner on the contractors and therefore the state has no liability towards the petitioner. Next one. The case of the petitioner is that the petitioner is a MSME and is your registration as an MSME is not here.
My lord. My lord, may take it as a limited liability partnership.
No, no, you said MSME. MSME, you are not registered.
Uh,
You
My
don't,
lord, we do have the certificate, but it is
don't write that.
not a part of my written
Don't write that.
application.
You say that it's a company who's engaged in the business of supply of bitumen products. Full stop. On receipt of a work order bearing number, page 18, number so and so, dated 25/1/2021, issued by the Executive Engineer, Rural Works Division, Sagali, SEGA LEE, the requiring supplies of bitumen within bracket hot mix bracket close material to how many sites are there?
My lord,
6, 7, 8, 9, 10, 11 sites.
11 sites.
On 1 month credit for a quantity of 77 MT calculated at the rate of 51,500 per metric ton, amounting to a total sum of rupees 5,24,35,500, which was issued by the Executive Engineer of the DTIU-Roman 2, the petitioner has made the supplies next paragraph. The learned counsel for the petitioner has stated that, has submitted that as per the contents of the work order, the petitioner was to give 1 month credit for the supply to the against each work mentioned therein. Against each 11 works mentioned therein. And that the said work order contained 3 terms and conditions which are as follows. Page 19. Next paragraph. It is submitted that few of the bills were raised in the name of the consignee, i.e. the executive engineer, RWD, Sagali, indicating the name of the buyer, and in some of the invoices, the same has been raised in the name of the concerned contractors. First of all, it is stated that the petitioner had exhausted all his effort to have payment released from the contractors, but as the Rural Works Department had made payment to the contractors and he was not paid, in terms of clause 3 of the work order, upon service of notice on the respondent number 3 and on non-receipt of payment, the present petition has been filed under Article 226 of the Constitution of India. Where is the notice to the executive engineer?
My lordship, page 50. Section 7.
Next paragraph. Per contract, apart from raising the preliminary issue, the learned standing counsel for the RWB has submitted that the state respondents had no liability for payment of the bills raised by the petitioner, as the work order clearly indicated that the material was to be supplied to the various contractors. It is submitted that the said work order does not contain any clause that the payment would be made by the state government. And moreover, as bills were issued in the name of the contractors, the state had no liability to make payment of the amount claimed by the petitioners. Next, insofar as the preliminary objection is concerned, find from the contents of the work order dated 25/1/2023 issued by the executive engineer oblique DPIU-Roman 2, Office of the Executive Engineer, RWD, Sagadi, that the said supply order is issued in the name of the petitioner, requiring supply of bitumen within bracket hot mix, oblique cold mix, emulsion, EMULSIUN, bracket closed. Bitumen, bracket hot mix, cold mix, emulsion. Full stop. The said work order clearly mentions about discussions held by the executive engineer concerned with the representatives of the petitioner, and by the said work order, the executive engineer concerned within bracket respondent number 3 had accepted the petitioner's commercial terms and conditions for supply of bitumen material on 1 month credit from the date of supply of material at site towards lump sum advance payment. And accordingly, the petitioner was directed to start supplying the material against each work as soon as they received the said supply order. Full stop. The 3 conditions contained in the said work order does not clearly spell out that the liability of making payment was on the contractors. Full stop. The respondent number 3, next paragraph, the respondent number 3 did not specifically disown liability to make payment. Rather, clause 3 of the terms and conditions indicate that the payment shall be made in the within bracket one month time as and when contractor payment was made. So here also it is not indicated that the payment of the petitioner should be realized from the contractors. So therefore, the court is inclined to hold that the stadium objection towards the maintainability rate petition is not sustainable. And the full stop, the work order issued by the respondent number 3 would bind the government of Arunachal Pradesh in the Rural Works Department on account of vicarious liability of the state on account of representation made by the executive engineer within bracket respondent number 3. Next paragraph. Full stop. Next paragraph. Court is unable to accept the stand of the respondent numbers 1, 2, and 3 that the executive engineer was not authorized to issue this order for supply of bitumen. Full stop. In this regard, it may be mentioned that I'll take a break and come back again.
Hello.
It may be mentioned that in paragraph in paragraph 4 within bracket Roman 2 small of the written of the affidavit in opposition, which is signed and sworn by the Undersecretary to the Government of Arunachal Pradesh, Rural Works Department, that wherein he has stated that the private respondent numbers 4, 5, 6, and 7 was awarded the contract work under PMGSY by the state government under Rural Work Department from a Sagari division, and on good faith, the executive engineer of the Sagali RWD issued a supply order for supply of bitumen in favor of the private respondent numbers 4, 5, 6, and 7, which is within the knowledge of the petitioner. Next paragraph. This nothing on record, nothing is brought on record by the by the respondent numbers 1, 2, and 3 that bitumen was a restrictive item and cannot be supplied to a contractor without a work order by the executive engineer. Full stop. If the supply order was intended for the payment for the supply was intended to be made by the contractors, in view of the representation made in clause 3 of the terms and conditions of the work order dated 20
25/1/2021.
20
25/1/2021.
25/1/2021, it was incumbent on part of the executive engineer to ensure that the said condition was complied with. Next paragraph. Accordingly, the court is of the unhesitating opinion that the petitioner had made supplies to the contractors purely in terms of the work order dated 25/1/2021, and the said work order constitutes a binding agreement upon the state respondent numbers 1, 2, and 3 to honor the supply order issued by the respondent number 3. Because of the vicarious liability the state would have for the actions of the respondent number 3 in issuing the supply order and assuring to the petitioner that the payment shall be made within 1 month as and when contractor payment is made. The said clause number 3 amounts to acceptance of debt by the executive engineer, oblique BPIU-Roman 2 of the liability of the state to make payment. Next para. A mere omission on part of the petitioner to raise all the bills on the executive engineer will not entitle the state respondent numbers 1, 2, and 3 to wriggle out, WRIGG, wriggle out of the contract, which is inherent in the supply order dated 25/1/2021. Next para. It is not in dispute that the contract work would not be undertaken by the contractors due to lack of bitumen or non-supply of bitumen. Stop. Therefore, if the respondent, if the petitioner has done his part of the contract, the state respondents would have to comply with their part of the contract in making payment in the terms of the said work order. Next para. Accordingly, the objection raised by the learned standing counsel for the RWD is not accepted. Next para. According to this, petition stands allowed. Next para. The state respondent numbers 1, 2, and 3 are granted 4 months time from the 4 months time to make payment of the contractual dues to the petitioner, commencing from the date on which a certified copy of this order is served of the furnished to the respondent number 3, i.e. the executive engineer. Give the full name, huh? So and so. According to this, declaration stands allowed. There shall be no orders to cost.
My lord, liberty may be given to the state respondent to recover from the private
Okay,
contractors.
yes,
If
yes,
it is not observed again, they will take advantage of it.
Needless to say that upon such payment being made, the state would naturally have all the power and liberty to realize such payment from the contractors in the event those payment on account of bitumen is also released to them.
But this recovery should not be a bar for delaying my payment process.
No, that I've not, it's not made a part.
Knowledge.
Hello.
May I, Lordship? Lordship, I am representing on behalf of petitioner. So, Lordship, senior counsel is out of station. So, my prayer would be, actually, Lordship, because of sudden damage of the family member, they could not appear today. So, my prayer would be, in this grip of time, on humanitarian ground, I
You
would pray
want
for,
an adjournment.
yes.
Okay, have courage to say so. Don't be afraid.
Yes.
Correct. Never be afraid to court.
Your Honor,
Ah.
at least after 1 week.
Okay. Don't be afraid. You're afraid. No, don't be.
Little bit.
You have a long way to go. You are young people. Correct.
Yes.
Articulate and say, if there is a bereavement, don't think that we'll be so unkind to your prayer. Okay, both sides are represented. It is on behalf of the counsel for the petitioner, it is submitted that the counsel holding the brief is in bereavement. Accordingly, matter stands adjourned today, list after.
My lord, on third of October, my lord.
Third is just before vacation. It will be very.
Yes, my lord, because there is some urgency here. Why, my lord? Because
Okay, make
NEC
it-
is hammering us and
we-
the contractors are also
we
hammering.
make it 30
30.
September.
Okay.
This last days before vacation are very uncomfortable days for hearing.
In that case, first Tuesday, my lord, 1st October, my lord. 1st October, my lord. 1st of October.
1st October, okay,
Yes.
1/10/2024, okay.
Highly obliged.
Obliged.
I beg your lordship. Your lordship, in this matter, the portal for submitting the bid documents, it has been opened. My bids have been accepted yes,
Oh, very good.
today.
Okay, so we close this matter on the.
Yes,
10th?
your lordship.
Okay. Mr. T. Tarsen, London Council for the Sering.
Yes, your lordship.
We call it Sering.
Yes, your lordship.
Okay, TSERING, the London Council for the petitioner, upon instructions, has submitted that the bidding portal
Yes, your lordship.
of the respondent authorities was opened and the bid of the petitioner has been accepted in the portal. Accordingly, he has instructions not to press the matter. Mr. G. Tarak, on standing counsel for the RWD is present. Mr. Matter stand closed on satisfaction.
There is interim order that can be vacated.
Past release stands vacated.
Highly obliged, your lordship.
But Mr. Sering, just a moment. Yesterday, your tenacity, I appreciate. I should have said very good yesterday, but yesterday somehow I forgot.
Regarding your lordship, yesterday's
Your
matter,
tenacity in that matter, which item I won't remember, but
item number 1 it was.
it was
in the
item number
motion.
1. Very good. You withstood the tide.
Your
Very
lordship,
good.
I am grateful for that thing.
No, but it's good. I appreciate. Yesterday I should have said it, but I forgot. Then in the evening, I realized I should have appreciated you then.
Oblige, Your Lordship.
Yes. My lord, kindly take up item number 14, my lord. So item number 14.
My lord, subject to convenience on the part of the my lord counsel for the petitioner, my lord. May I pray that my lord matter may be disposed of at this stage, my lord, because pleadings are completed, my lord, only nothing starts survive. My lord, department, my lord, decided to initiate a press tender, my lord. But I don't find, my lord, in the affidavit, my lord, the reasonable justifications, my lord, in the affidavit filed by the Union of India through the, my lord, the BRTF, my lord. So therefore, my lord, only this is a developmental work and national strategic importance roads are being halted, my lord.
I'm sorry, please repeat again. I couldn't follow. Please repeat again.
My lord, there, the NIT was issued.
Yes.
And that they have participated in the tender process. Thereafter, my lord, the technical and the financial bid was open, madam, and they have been categorized as L1. In the meantime, my lord, the department, the higher authorities, my lord, decided to go for the press tender, my lord. And in the press tender, my lord, only technical parties, my lord, some technical errors have been done. My lord. Only because of that reason, only, my lord, the authorities have decided to go for the press tender. My lord. And my lord, my lord, their submission is, as per the, my lord, the affidavit filed by the Union Revenue, my lord, BRTF, my lord, there is on justifications, the justification is not available, man. So therefore, only, my lord, the higher authorities instruction, my lord.
Yes.
Here, my lord, petitioner was declared L1. Thereafter, my lord, the rate was verified. Lordship, may kindly proceed. Now, my lordship, come to page number 170, my lord. Reasons they have stated, my lord.
What is the tender condition?
My lord, page 13 is the NIT, my lord. Page 13, NIT is the IT. NIT, my lord. It is regarding construction of road, my lord. NIT was issued in August 2023, my lord. Lordship will find the particulars at page 39 of the writ petition.
Page 39.
39,
Yes.
my lord, yes.
Yes, where is the clause?
Regarding
Regarding extension, that is the ground.
No, my lord, bid validity was extended, my lord. This, my lord, tender was issued, I was declared L1. And my bid validity
No,
was
the,
also.
the ground is technical ground shown is that the validity of the tender had expired and you did not.
It was with respect to other bidders, my lord, who have not extended their validity, my lord. I have extended, my lord. The
You've done it.
petitioner-
Where is that?
That is in the affidavit itself, my lord. in the affidavit in opposition, my lord.
Where is that?
My coming, my lord. It is at page 60, my lord.
Page
Page 60, thereafter, lordship will find it.
60,
Oh, sorry, I am sorry, my lord. 170 of the affidavit in opposition filed by the
170.
170, my lord.
One seventy, yes.
And more, it is more precisely given in page 172, my lord.
Okay.
And lordship may see
So,
page 172.
That is the only ground?
Yes, my lord. And my lord, there is one more reason they have given, my lord, that your lordship will find, my lord. At page, my lord, 175, my lord.
One seventy-five.
More or less grounds are same, my lord. They have given it. Grounds are same, they have given it, which your lordship. has-
Where?
Page 175, my lord. Then lordship may see
Close?
clause 3, so clause 2, A, B, C, D, they have given the grounds.
That is the only ground?
Only, that is
That
only.
is only
ground.
ground?
Yes, my lord.
Okay.
Yes, madam. That is the only ground, my lord. The bid validity, my lord, was extended by this petitioner,
And obviously the other bidders,
my lord.
they will never come to court for that ground.
Exactly, ma'am.
Correct. So we allow the
Yes,
repetition.
my lord, yes, my lord, that was the only technicalities, my lord, the infirmities found by the higher authorities, my lord. Because of that reason, my lord, the already direction was given to the, my lord, the authorities concerns to, my lord, the float NIT, press NIT, my lord. Accordingly, it was uploaded, my lord. By, my lord, the third round of repetitions, my lord,
267, my lord.
67, my lord. Wherein, my lord, that fresh NIT was challenged, my lord.
That has been stayed, my lord.
And this noble court was pleased enough to, my lord, stay the, my lord, the process, my lord. Without knowing the, my lord, the order passed by this noble court. Though I was present, my lord, but that was not, the order copy was not made available on time, my lord. It was already projected in the, my lord, the web portal, my lord. In the meantime, my lord, judgment and order passed by this honorable court by way of interim, my lord, that has been communicated to the department, my lord. Without knowing that, my lord, without receiving the, my lord, order passed by this honorable court, that web portal was already uploaded, my lord. So in therefore, my lord, this contempt petition is also come up, my lord. After, my lord, the receipt of the order passed by, we have not done anything, my lord.
There are two NITs, my lord. There are two NITs, my lord. There are two NITs, my lord. One is item number, my lord, 14, and other is item number, my lord, 12.
Okay, there'll be separate orders. That's the same. Heard Mr. R.S. Mishra, and counsel for the petitioner. Also heard Mr. M. Katul and DAGI appearing for the respondents. Petitioners. Next, brother. By filing this writ petition under Article 226 of the Constitution of India, the no, but Mr. Mishra, you still have to,
My lord.
you still have to amend it.
My lord.
You'll still have to amend your writ petition.
My lord.
Without that, we are unable to grant you any relief. You see, notwithstanding that this interim order is there,
My lord.
but there is a tender in existence.
But that has been stayed by this honorable court.
No, no, question of stay and question of wiping out is,
My lord.
it's not still wiped out.
My lord.
So the tender is there.
That has been put to challenge in item number, my lord. 15, my lord.
To
Item number 15, my lord. That tender has been put in.
Tell me the writ petition number.
Writ petition number 267, my lord.
267.
That has been put to challenge, my lord.
Then first order, item 267. But Mr. R.S. Mishra, petition, Mr. M. Katul, and it's DSGI appearing for the respondents. Next order. Filing the replacement under Article 226 of the Constitution of India. The petitioners have assailed the legality of the re-tender notice number so and so, page 15, dated 27/6/2024. Next paragraph. The case of the petitioners is that tender was published by the respondent authorities in their web portal on 24/8/2024, bearing tender number you'll find it page 2, as you know, tender number so and so for the following work. It's there only, huh? Full stop. The petitioner was successful. The petitioner and two others were successful in the opening of the technical bid on 29/2023. Full stop. The financial bid was opened on 23/3/2024. And on opening of the financial bid, the petitioner emerged as L1 tenderer. Full stop. It is also projected in the writ petition that the respondent authorities had requested the petitioners to extend the validity of the bid till 27/2024, which was done by the petitioners. Full stop. However, the said tender was not finalized, and accordingly, the petitioners had approached this court by filing WBC 254 of 2024. Full stop. This court, by interim order passed on 26/6/2024, while issuing notice, restrained the respondent authorities from retendering the said tender. Full stop. However, retender notice dated 27/6/2024 was issued. And accordingly, the present writ petition has been filed. Next paragraph. The per contra, the learned DSGI has submitted that there was no attempt by the respondent authorities to overreach the order of this court dated 26/6/2024, interim order of this court dated 26/6/2024. So, however, full stop. It is submitted that the said order was not made available and or downloaded and transmitted to the respondent authorities on the same date, i.e. 26/6/2024. And due to lack of such communication, a retender was issued on 27/6/2024. It is submitted that after the interim order of this court was communicated to the respondent authorities, the tender dated 27/6/2024, which is assailed in this writ petition, has not been acted upon. Next paragraph. Referring to the affidavit in opposition submitted by the respondents, the learned DSGI has submitted that that as per the terms and conditions of the bid, the validity period of the bids submitted by the tenderers of the bidders was, Mr. Kato, what is the date? Validity was up to when this bid submitted in the earlier tender was valid up to which date? The price bid was valid up to
Petitioner bid was valid up to 20th July. Petitioner's bid was valid up to 20th July.
Okay, 27/2024, and accordingly, the respondent authorities had requested all the bidders to extend the bid validity full stop. No, this
Sorry,
is
madam.
your subsequent, no, you're wrong.
No.
Captain, requested to extend it, stop. It is submitted that though the petitioner, the petitioners had extended the validity of the bid till 27/2024, comma, but there are two other bid successful, but there were two other bidders who had qualified in the technical bid. But as the bid validity was not extended by them, who were L1, L2 and L3 respectively, comma, the respondents took a conscious decision that opening of financial bid in respect of two bidders who had not extended their financial bid may lead to legal complications. And therefore, a decision was taken by the respondent authorities to retender the matter. Full stop. Accordingly, comma, the learned DSGI has supported the action of the respondent authorities in issuing of the fresh bid. Next paragraph. Therefore, comma, the only reason to issue a fresh NIT was because the financial bid of L2 and L3 bidders were also open, though they had not extended the validity of their financial bid. Full stop. Next paragraph. In view of the nature of defense taken by the respondents to justify the issuance of a fresh NIT, the court is of the considered opinion that in the present case in hand, comma, the petitioner number one, the petitioners had emerged as L1 bidder. And therefore, and the petitioners have not questioned the opening of the financial bid of the L2 and L3 bidders. Moreover, comma, there's nothing on record to show that the L2 and L3 bidders were also aggrieved by opening of their financial bid without the validity of bid being extended. The court is of the considered opinion that the petitioner has been able to make out a case where the retender dated 27/6/2024 is not found to be justified. Next paragraph. Therefore, the prayer made in these repetitions deserves to be and is accordingly allowed. To stop. Next paragraph. Subject to the condition that the petitioner extends the validity of their price bid up to this date, i.e., the date of this order, i.e., 29/2024, comma, the court is inclined to interfere with the Retender notice. Retender notice
Page 185.
number is page 3.
Page 185, man.
Page 3. Tick mark for so and so. Next para. It is made clear that 7 days time is granted to the petitioners to submit to submit their undertaking for extension of their financial bid till the date of this order. The retender notice is set aside and quashed. However, if the extension of the price bid of the petitioner is not furnished to the competent authorities of the respondents, being the accepting officer, right? Officer, Project Brahmank, within bracket respondent number 4, comma, the retender the respondent authorities would be entitled to proceed with the retender, and on the non-furnishing of the extension of the financial bid as on the date of the order, comma, this order shall not be treated as an interference with the original tender dated 23/8/2023. It's a conditional order. If they give the extension of the price bid till today, then that is interfered with. And if they don't give within 7 days, then that goes.
Extended plus.
No, you are not saying for other compliances. Mr. Needless to say that other compliances will also be required to be. Due compliances will have to be done in accordance with the procedure prescribed. And that is one. Then comes 254. In 254, you just say that heard Mr. R.S. Mishra, counsel for the petitioners, and Mr. M. Kato, done at DSGA, appearing for the respondent numbers 1, 2, and 3. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioners have prayed for a direction upon the respondent authorities to finalize tender number that first one, BMK 08 dated 23/8/2023. Stop. Next para, in the said context, the court has passed an order in an analogous matter, being WPC 267 AP of 2024. And a conditional order has been issued to stop. In view of the said order, comma, no order is required in this writ petition, as the decision of this court in WPC 267 AP of 2024 shall be applicable here. Accordingly, this writ petition stands disposed of in terms of order dated 29/2024, passed in WBC 267 AP of 2024.
My lord, in WPC 255, my lord,
Huh?
in WPC 255, there was no written notice, my lord.
There was no return.
No, my lord.
Here, what is your defense? In this case,
Grounds are same, my lord. Same.
same ground.
Same ground, my lord.
Okay. In this case, only the tender number will be different. It will be. This will be. You say heard Mr. R.S. Mishra and counsel for the petitioners and Mr. M. Katul and a DAG appearing for the respondents. Next paragraph. By filing this repression under Article 226 of the Constitution of India, the petitioners have prayed for direction upon the respondent authorities to finalize the tender number
Page 39, my lord.
It is then the cause list is very easy for them to find out.
My lord.
Number 2, page number 2. Like in respect of so and so work. First off, the case of the petitioners is that they had participated in the tender referred above. And they had, and the petitioners along with two other bidders were found technically responsive. Also, thereafter, the price bid was opened on 23/3/2024. However, though the petitioner was found to be L1, now, which is the date of opening, 23/3 or 24/3? In page 8, you write both dates. Para 6, you say 23. In para 7, you say 24. Which is right, my lord.
Should be my lord 23 only.
Which is right date?
20.
This is 255. Item number I won't remember. 255.
Item number is 12, my lord. 255.
No, in para 6, he has given a date of opening on 23/3. In paragraph 7, he is writing 24/3. So now which is correct? Tender was opened when? In your note sheet, there should have been there. Please find out from your note sheet in your affidavit.
It would be 23/3, my lord.
Huh?
23/3. In my representation, I have written 23/3.
23/3.
My lord.
Okay, 23. Okay. And so accordingly, the respondent authorities, by their letter dated 16/5/2024, informed the petitioner that he was L1 bidder. First off, however, although the petitioner had extended the validity of his financial bid up to 21/7/2024, as per request made by the authorities, the work was not awarded to the petitioner, and according to this writ petition. Next paragraph. The learned DSGA, same ground. Next paragraph. This, finding is same, that is there, so. Just accordingly, the notice of the constitutional opinion that there would be no impediment on part of the respondent authorities to finalize the tender in question in accordance with law. Next paragraph, however, comma, this object is subject to condition that the petitioners would submit declaration in due form, in proper form to the respondent number 3, i.e. the chief engineer, BRO accepting officer regarding extension of their financial bid till, I said, don't make it till today, it will be difficult. You'll have to take some time. Till, make it 309, extend the bid till 309/2024. How much time will you take to award the order? You need more time, or? Because the extension of the validity will be for certain days, only we say for 30 days from today. Okay. Extend the validity for 30 days from today, i.e. 29/2024. First of on extension of such bid validity, comma, the respondent authorities shall finalize the tender number so and so in accordance with. Next paragraph, same clarification. If it is not extended, then
My lord, only small correction, my mistake, my lord. The date would be 21/3/24. It is at page number 176 of the affidavit in opposition. Bid validity opening date, my lord. 21/3/24. It is in their affidavit in opposition, my lord, not sheet, page
Page number?
21/3/24, my lord.
page number
Page number 176 of the affidavit in opposition, my lord.
6.
176, my lord, paragraph number 8, my lord.
Paragraph number 8.
8, last paragraph, my lord. Was opened on 21/3/24. It was my mistake, my lord.
Okay, 21/3/2024.
My lord. My mistake, I am sorry, my lord.
Not 23, huh? 21/3. Okay.
Then, my lord, this content may also be closed, my lord, item number 13. Item number 13, the content may also be closed since lordship is interfered with this.
13, let me have that. Heard Mr. R.S. Mishra, learned counsel for the petitioners, as well as Mr. M. Kato, learned DSGI, appearing for the respondents. Next paragraph. By filing this contempt petition, the petitioners have alleged willful and deliberate disobedience of the order dated 26/6/2024, passed by this court in WPC 254 of 2024. Stop. Next, President, counsel for the petitioner has submitted that an interim order was passed on 26/6/2024. To the effect that
Page 13, my lord.
to the effect that without the leave of the court, the respondent authorities shall not retender the execution of the contract. Page 14, the same, This is an item number 254, the same. Page 41 of item, same. Item number, chart number. First of- However, despite communication of the order, copy of the order to the respondent authorities, comma, the said work was retendered by retender notice
Page 15, 27,
Dated-
6, 24.
27/6/2024. Next para. The learned DSGI has submitted that no contempt has been made out because the copy of order dated 26/6/2024 was communicated only on 27/6/2024. This is evident from the documents appended to this contempt petition. Being the notice dated 27/6/2024 within bracket annexure C. Full stop. Accordingly, it is submitted that on the same day, without having notice of the communication of the order of this court, the retender was ordered on 27/6/2024. Next paragraph. In view of the explanation given by the learned DSGI, the court is inclined to accept the statement of the learned DSGI that as the copy of the order dated 26/6/2024 passed by this court in WPC
254.
254 AP of 2024 was communicated on 27/6/2024, on which date the retender was already issued. The court is inclined to hold that no deliberate and willful disobedience of the order of this court dated 26/6/2024 is made out. Full stop. Next para, according to having ruled that there was no willful and deliberate disobedience of the order of this court, the contempt petition stands closed.
Deeply obliged, madam. Obliged.
Right, please, Joseph.
Yes,
My lord, service is not complete, man.
not complete.
Yeah.
It's all matter. Can I know the procedure, how this steps are routed? Notice are issued how?
Through police, petitioner,
To
police.
police.
Oh,
Can I have the service report? Service report. Police report.
May I please, Lordship? Lordship, I'm appearing for the respondent number 2.
Oh, you are appearing.
Yes.
Service
So-
complete then.
I'm appearing for
Respondent-
respondent number 2. So petitioner
Please.
took 2 years, 10 months to causing served notice to the respondent number 4.
No, I would have been happy to accept your submission, but unfortunately I cannot. Because Mr. Som does not serve.
Yes.
That is why I'm asking, how is the service made? If it is made through the police, we can only be sorry. Correct?
So it's inordinate delay in serving, causing the notice, inordinate
But
delay.
how will he be responsible? Please tell us. Mr. Som does not serve. We don't ask our officer of the court to go and serve. Correct? So he can only take steps. It is for the police to serve. That is why I asked this question. Correct? So despite the delay, okay, then the service is completed. Give him copy.
Respondent 3 is not complete, my lord. Headmaster.
the headmaster.
Headmaster.
This is. What is the order impugned herein? Please show us that order.
My lord, this is regarding, my lord, there was a miscellaneous application for
Why is this headmaster required? I want to know that.
headmaster government,
No, I understand.
Middle
Why is he required?
because there is a, my lord, some tempering of the exact word.
No, show us that because I want to understand why a headmaster is required.
No, he has to make the, my lord, given affidavit in opposition, whether he has corrected or
Show us the order because then I would understand in what context the order is passed and why this headmaster is necessary. That's why we are asking you that. Why in a criminal petition, headmaster is required? What is the age of the child?
that time actually, lordship, he was only 14 years.
Where is the FIR?
This page 19, my lord.
Page 19. Now, who is the accused?
On the two students, one is from Radhang
I would
School
like to
and
apprise that
another is
today
from
early morning, 4 a.m., Miss Ribu Dinia, son of Sanso, informed to my sister, younger sister, so and so, that my son was found unconscious with multiple head injury. And later my sister informed me that I was found, my son along with so and so, in Yes. I'm not understanding this FIR. Page 20.
20, man.
Early morning, Miss Ribu Rinia, daughter of so and so, informed to my sister's younger sister, Srimati so and so, that my son, Age Assam, was found unconscious with multiple head injuries at secondary school 0 ground. Later, my sister was informed me, and I found my son along with so and so in the gate. So two people are injured. But you say that Ribu Rinia informed you. This informant, who is for the informant?
Hage Richo.
Hage Richo, who is
Yes.
appearing for him? This, what is, what is there? What is this case?
Lordship, no one appeared, Lordship, because
Huh?
the service upon response number 4 is not yet completed, Lordship, with the victim.
4 is Hagaricho.
They have implemented, Lordship, through the IA, Lordship. We have received a copy, Lordship, on 8/2/2023, Lordship.
I'm sorry, my lord, I may go to bring my spec, my lord.
Yes, yes.
Well,
To this IA, Lordship, they have implemented the person, Lordship, as a respondent number 4, Lordship.
Acha. If this is POXO Act, the person says that he was minor at the time of minor at the time. Now, what is the order of the court?
Okay, Lordship. Within the affidavit in opposition filed by respondent number 2, Lordship.
Records are available? Santosh? Record is available? LCR? Huh? Not available.
This order is in the affidavit in reply, affidavit in opposition filed by the respondent number 2.
There's no order calling for the record. This 2019 matter. You never paid for the original record being called.
I don't know, Lordship, page 25 of the criminal revision petition, Lordship, there's an order, Lordship, 9/12/2016, Lordship, where the direction order passed by the London District Assistant Judge UPA. Yes, impugn order. I think to the 81. It is not 96.
So where is that document? Where is the tampered birth document? The tampered birth document is not there. I'm not finding it.
My lord, the document has not annexed.
What is the name of that minor? Tasu Taruk. Tasu Taruk. Now, where is the tampered document?
my lord, order is at page 27, passed by the London District Session Judge, come special.
No, I have understood that. You see, the petition was rejected because the document called for was tampered. Now, where is the tampered document?
As per order, register
No,
book,
no, it
admission
it
register.
shows the tampered document. Where is the tampered document?
Next name. So, Lords, it appears from the record that the temporal document has not been annexed by the petitioner.
Not been annexed.
Yes.
You see, we can't do anything about it. In the complaint, in this revision petition, you are not asked for calling of the records. The records were never called for. 2019, now we are 24, 5 years. Your prayer was that the accused was a minor. And that is disproved because the records called for were found tampered. And that is why it was rejected. Now you have to show us good reason to accept your statement and to treat him as a minor, because that inquiry is required to be made. And that inquiry was made. So how that tampered document was created, what is the difference? Nothing is there. Even in a petition, you have not said those things.
May I read the order, Madam, order passed by the learned district and session judge come.
No, if you
Special
have a
judgment.
birth certificate, where is that birth certificate? You have the original birth certificate with you. Where is that? And in the original register, it is tampered. Therefore, it is found, you see, an inquiry must be based on a document which is existing on record. If it's a tampered document, you can't be held a minor. What is wrong in the order?
It was an observation made by the learned district and session judge.
No, it's not an observation, it is a finding. There is a difference between observation and finding. It is on the finding arrived at by the learned district judge that the school records showed that the dates are tampered. Your application to be treated as a minor was rejected. It's not an observation, it's a finding. Why that finding is wrong, I'm not getting it. Why that finding is wrong? You don't annex that document. Why you are not annexed it, we don't know. We are 5 years now down the line. Your trial has been stayed in the meanwhile just for the juvenility.
Madam, that admission register is a big one. It is a bigger one. It is difficult
No,
to
but when the court takes cognizance of a document, definitely a scanned copy of it or a photocopy of that school register was there on record. Court must have looked into it. Again, moreover, in the affidavit filed by the respondent number 2, they have taken a ground that your application is delayed by 200 something days.
Yes.
And the delay was never condoned. So technical ground taken. In their affidavit somewhere he is written more than 200 something days of delay. You are respondent number 2.
Yes, my lord.
We have not given a copy of the affidavit.
Affidavit is not with
Not
you.
given.
This is 2019 affidavit. You don't know that an affidavit is filed. The affidavit is filed long back.
Yes. Affidavit already I have served to his junior.
You have served. This is filed in 2021, so 27th August 2021.
Lordship, I served to the T. Torum, the East Junior Council.
What is the name?
T. Torum.
T. Taran. And there's a conviction recorded. After trial, conviction is recorded.
Yes.
Hmm?
Yes, already convicted.
He's already convicted.
Yes. And yes, the prior of
But
portion of the-
then, Mr. Som, you're again in a very bad spot. If there's already already order of conviction,
Yes.
your revision would not be maintainable. Then it is in appeal, you will take that ground, that you are a minor at that ground. This revision petition has to be closed. An interlocutory order cannot be challenged in a revision when the trial is already ended in conviction. The interlocutory order loses its.
Lordship,
Get merged.
Lordship, may I take you to the page number 11 of petition,
Pardon me?
criminal revision petition? Page number 11.
Page number 11.
And last portion is pending disposal of the revision petition. It is further prayed that the Lordship may be pleased to suspend the proceeding initiated by the Nanda District and Sessions Judge cum Special Judge West Session Division. This is their prayer of the petitioner. So already convicted two of the accused.
This is no point asking for this presence of respondent number 2 and 3. We have to close this revision petition. It's a conviction of which date? What is the date of the judgment? Can you tell us?
Date of judgment.
Judgment of 2018. 2018.
I'm not aware of the fact that whether they have been convicted or not.
Yes, it is there.
Judgment,
Look at this.
my lord, in my petitions, judgment
Look at this.
is in
judgment.
annexure
Look at this.
P3 and P4. P3 and P4.
Date of judgment.
Convicted sentence order. And this revision is filed in 2019 after conviction.
No, before, pardon.
No, I think this is 19 you filed. Conviction is 18. Nothing survives. This is when we have to close it. You avail proper remedy.
Definitely. 18.
They're closing it. Interlocutory order stands merged with the final order. That's why I said that even at the order stage, I'm ready for hearing. Because unless we look at the file, you see there's a miscarriage of justice. From 2019, you are waiting for what you call this criminal petition. He files an affidavit in 2021, discloses that in 18, you have already been convicted. Now in appeal, you will have a very bad time convincing us for condonation of delay.
No, no way on my.
Heard Mr. T. Somdaran, counsel for the petitioner, Mr. L. Hagel and APP for the state.
Lordship, APP Lordship, G Tadona,
T. Tadol and G Tadot and an APP for the state. And Mr.
Armilo.
Milo,
Yes.
learned counsel for respond number 2. Next para. It would be appropriate to mention herein that during the pendency of this criminal petition, filed under section 401, read with section 482 CRPC, comma, the original complainant who had lodged an FIR had expired, and pursuant to the orders of this court, comma, the respondent number 4 was impleaded as a legal representative of the deceased complainant. Full stop. The representative of the deceased complainant was added as respondent number 4 as the charge of offense for which the son of the petitioner was being tried includes the charge under section what happened to the POXO prosecution?
6. POXO case number.
What happened to the POXO prosecution? Is not proved. POXO is not proved.
POXO case.
What happened to the incident of sexual assault?
POXO cases there. Two cases now.
It's not under POXO, it's under gang rape. It's not under POXO, it's under gang rape 376 D.
No. Then something is wrong. Something is wrong. You see, come to page 29 onwards. Para 21, 22. Then 23. They took her so and sexually assaulted. So if that be so, then what has happened to that? And she, whether she is a major or minor, 376 is not added. Is it a case of mistrial?
Section 4 is there. Section 4 of POXO Act charge.
Is charged.
Yes.
See para 26, very clear, explicit. 26, 27 of the judgment. But where is the conviction? He is not charged. Order of sentence is under 302, 392, 34. What has happened to that POXO charge?
Convicted, you know.
So, Tadu, what is happening? The case of mistrial. Where is the charge from? Where you're reading charge of POXO 4? Where is that? It is this victim who was raped, she has died.
Yes, yes, my
The
lord.
victim who was raped had died.
Yes.
Yes.
So please be sure and then say. Don't have a question mark in your face and then say.
Could you
Who-
repeat
who
the
died?
question? Could you repeat?
Who has died?
Or
Who
Hage
has
Hassan.
died?
Persons, Hage Hassan.
And what about the victim? She is alive.
She's alive. Yes. There's two FIR. One is
Where is the charge under POXO? Please tell us, show us.
one is for 302 and another is 372 and
Where is-
section
where is
4 of
that-
the
Where is
POXO.
the charge? You're referring to charge where? Where is that?
My judgment may be kindly refer to the my
No, I'm there with your judgment. That's why I'm finding out. So. You're reading which page?
page number 20,
20A.
21.
20. Yes, I'm there. In this page, there is no.
Page number 21 is judgment of 302.
Yes, 325. It was registered under
Another
325.
another judgment I have annexed that is in the page number.
Then after that, the charge was converted into 302, 392 and 34.
May I take you to page number 56?
Page?
An excerpt fee-4 of my
Page.
page number 56, my lord.
56.
Mm.
Oh, that is a second trial.
Yes.
It's a separate trial.
There are two
Yes.
FIR.
In this separate trial, the accused are Tasu Taruk.
Yes. Both the accused charges in the 302 and the 376 1D IPC and read with section 4 of the POXO Act.
Then, Mr. Som, you are you're in a very difficult position now. There are two convictions against you. POXO is tried separately and 302 is tried separately. And in both of the cases, you are found guilty. Is added because the son of the petitioner was also separately charged for committing offense under section 376 within bracket small I within bracket capital D IPC read with section 4 of the POXO Act. Yes, but this order is not sustainable.
Your Lordship, I filed my affidavit, Your Lordship.
Oh, yes. You must understand that when I'm asking this question, I am aware of that. I'm asking you that the impugn order is not sustainable.
Your Lordship, I think,
Please, you're ready to argue the matter?
no, Your Lordship, I'm not in a position to argue this matter, Your Lordship.
Okay, why?
My senior counsel will appear this matter, Your Lordship.
Senior counsel will appear, but
Yes,
then
Your Lordship.
you find you sufficiently good enough to argue? No.
I'm not in a position, Your Lordship.
Why? Why you are unable to argue?
Your Lordship, I don't have the brief, Your Lordship, idea about
Oh,
the case, Your Lordship.
okay. Yeah, down the matter then. You read a book which is called Mario Puzo's The Dawn. You read that book, and I am asking you to read that book for only one line. There's only one line in that book which I am interested in. And I would wish that all lawyers who are upcoming like you would read that book. Only for that one line. You will have to, I'll not tell you what is it, but then the suspense would be lost. You read that book, find out one line which I am trying to refer. So next time when I am here, you, in the mention hours, you stand up and tell me that you have found out that one line in that book, The Godfather. It's translated into a movie also, but there's only one line in the entire book, only one line. About 10-15 words, not more than that. I want you to find out, search and find out that one line. Applicable for a lawyer. And if you read this and you apply, then I think you will always be blessed. And I'll tell you something more. You are young people, that's why you please tolerate the lecture for one more minute. You see, this is a profession which is a godsend profession. You know why? In no other profession, you will have 10 pockets, 5 in coat, 4 in trousers, and 1 in the shirt. So God has destined that it should always be filled up. So you have those in 10 pockets destined to be filled up. And that will only be filled up when you read that one line in that book and the brief. So next time, don't be ever present in court, at least in this court, without a brief. Correct? Yes. And why you don't appear with the court without a brief is the answer you will get only in that book. Mario Puzo, The Godfather. Read that. Not for the rest of the story, only for one word. I don't want you to read the rest of the story, but find out only one word, one line which I am interested in. Sure. And next time tell me. Sure. Correct, sure. Sure. Okay. In Kaun Banega Crorepati, they say lock kar de.
Lock kiya jaye, sir.
Lock kiya jaye. Okay. Good. All sides are represented. The Learned Counsel for respondent number 2. Respondent number, you are?
5.
5. Praise for an example. Prayer is allowed. List after 2 weeks.
Much obliged.
Yes.
Yeah, Lordship, I'm appearing on behalf of respondent number 1.
Please button up your coat first.
Pardon.
Yes.
I'm appearing on behalf of respondent number 1. So, matter is in fractures.
Why?
Yeah, since actually I'm appearing on behalf of Apex Customary Court, and this petitioner of CRP number 45 has approached before this customary court, and they had settled the matter before there. And same is already filed in affidavit.
Where is that?
That was filed on 27/0/007/2024, and subsequently date was fixed on 0/05/08, and later on again on 19/08. Again today it was fixed. It's especially for disposal only. Lordship. Where that customary judgment and even this mutual settlement deed, an application being filed by this instant petitioner.
When did you file it? When did you file it?
Filed on this 5th August of 2024. 05.
August 24.
And that copy has been served to that.
No, I am more interested in the copy I am having, whether I am having it or not. Huh?
Yes.
T Kipai.
Yes, Lordship.
Okay, okay, you are,
Yes,
okay.
T
okay,
Kipai.
We found it, huh? Yes.
Yes, as for this
Where is the
affidavit,
order? Where is the order?
that consent judgment is there in page number 156 to 158. And in 155, the application of that instant petitioner.
Page one?
155, the application being filed by this petitioner of this CRP 45. It's annexure A, that's application.
Okay. None appears on call for the petitioner.
Yes, petitioner last on previous two occasion. There is no issue. Even they said they will consult with their client. But all records are available before this court.
No, we don't know. If it's not there, it's not there.
Yes.
I can't say it's present. What? Mr. However, Mr. What is the name? I forgot.
My name is Tania Kipa,
Tanya Tibar, and
appearing on behalf of respondent number 1. That's a customary court.
then counsel for the respondent number 1.
And your lordship, I am for the respondent number 2.
And Mr.
J. Sring for respondent
J?
number 2. Sring.
TSCRING.
Yes, your
Mr. Ring, learned counsel for respondent number 2 are present. Next paragraph. The learned counsel for the respondent number 1, which is the All Arunachal Pradesh Gaon Bura and Gaon Buri Welfare Association, submits that the respondent number 1 is the apex
Customary court.
customary court.
Yes, lordship. And for perusal of lordship, that page number 149, that hierarchy of that customary court is also laid down.
Customary court.
149,
It is,
page 149.
it is submitted that
Paragraph 3.
during the pendency of this revision petition, the petitioner, namely Tana Sushil Tara, has once again submitted himself to the jurisdiction of the customary court by letter dated 24/10/2023, which is annexed as Annexure A to the affidavit in opposition. And that pursuant to the consent of the petitioner being given, the respondent number 1 has passed a consent judgment as per Nishi customary NYILEY dated 29/2/2024. Post of the said decision is also annexed to the said affidavit in opposition as Annexure B, which is passed on the basis of a mutual settlement deed dated 29/2/2024, which is annexed as Annexure C to the said affidavit in opposition. Full stop. Accordingly, it is submitted that the dispute between the parties has been finally settled by the respondent number 1 on 29/2/2024. Full stop. Next para. As the petitioner is unrepresented, comma, for ends of justice, the matter stands adjourned today. Next para, it is made clear that if the petitioner remains absent on call on the next date of listing, comma, then the court would presume that in view of the consent judgment dated 29/2/2024, comma, the petitioner is not interested to pursue the matter, and appropriate orders will be passed on the next date. Next para, list on, give a date after 2 weeks. You recorded this statement.
Printed off.
Congratulations.
May I-
Yes.
Here, my lord, I would like to take dusty service upon respondent number 8, private respondent number 8.
Who is appearing for respondent number 7?
7, they have appeared, my lord, but they are not filing wakalatnama on the last location, my lord. On 5/8/24, my lord. Someone has appeared, my lord.
Okay. Mr. B. Pichar and counsel for the petitioner has referred to the office note dated 16/9/2024 and has submitted that they would take fresh steps for service of notice on respondent number 8. First of prayer is allowed. The petitioner should take steps within 2 working days for service of notice on respondent number 8 by registered post with AD,
Dusty, my lord.
as well as by way of Dasti. Full stop. The process of Dasti shall be routed to the registry of the court, and upon service, comma, an affidavit of service shall be filed prior to the next date of listing. Next para. We take note of the next para, as per the said office note dated 16/9/2024, comma, neither wakalatnama nor affidavit in opposition is filed on behalf of respondent number 7. Full stop. As per order dated 5/8/2024, comma, the service on respondent number 7 was completed, and Ms. T.Y. Bhutia, learned counsel, appeared for respondent number 7. And on her prayer, 3 weeks' time was granted to file affidavit in opposition. This is item number
21.
But you should have informed her, her name will not be reflected in the cause list.
My lord, here my friend Mr. Karim Dabu is appearing. Actually, since March, he has been telling me that he will be filing wakalatnama. This is
No, no,
September.
I understand. Today you told him that the matter is listed today.
Not today, my lord. On the last
No.
occasion, I have informed him.
He may not be knowing that the matter is listed. Please inform him.
They are having the wakalatnama. They are not filing the wakalatnama because there is no stay order, my lord. There is
No,
no
no.
interim, my lord. They are
You
running
see-
away from the
You see,
proceeding,
had you shown us that you had given them a message or something,
my lord.
then we could have passed adverse orders.
My lord,
But today, their name is not reflected in the cause list.
my lord. But they have appeared, my lord.
You could have told him, even you could have told the court that, okay, in the morning also I told him
My lord.
personally, but that's the statement you should make.
My
Unless you tell him, how will they know?
lord, this, my lord, on, my lord, facts, my lord, since March, my lord, My friend knows this case. He has the wakalat number, but he is not filing the wakalat number. Why? Because there is no interim order. They are running away from the proceeding order. Now, due to the steps upon the response number 8 is not complete, my lord, I cannot proceed, my lord. They are playing the delay tactics, my lord, now. Private response number 7, my lord.
Okay. No, it's ex parte, what will happen? What benefit they get out of it?
My
They
lord,
get no benefit.
my lord.
7, we have already recorded his presence.
Yes, my lord.
But courtesy demands that you should give him a message or something that the matter is listed today. If they don't come, then we can.
Because
pass an
I
address.
see their intention, my lord. Since March, my lord, they are getting wakalat.
I'm more interested in notice. Otherwise, I don't pass any adverse orders.
My lord.
Next para, the notice on respondent number 8 is returnable on, give a date after vacation. Stop. Upon service by Dusty Mode, comma, an affidavit of service shall be filed prior to the next date of listing.
25th October, my lord.
List on Swenson.
25th, 24 October. Yes.
Okay, interim order passed at this stands.
No interim order.
No interim order.
Because of which they are running away, my lord.
Okay.
Obliged, sir.
Yes,
Your Lordship.
what is this IA for?
Your
What is this
Lordship.
IA for?
Sorry, Your Lordship.
What is this IA for?
Actually, Your Lordship, this is an condonation.
Condonation.
Lordship, in this matter, actually, we have supposed to take steps and accordingly we have taken. However, the step has not been completed yet. We may be allowed to take fresh step to Dusty Service, Your Lordship.
Miss
And Hondik,
N.
Hondik, Your Lordship.
N. Hondik.
And Hondik,
Okay, and Hondik Learned Counsel for the petitioner, sorry, applicant. Is present. Next for us, seen the office note dated 18/9/2024, comma, which indicates that service report in respect of respondent number 1 is not yet received. Next para, the applicant shall take fresh steps for service of notice on respondent number 1 by registered post with AD as well as by Dusty Mode. Next para, the learned counsel for the applicant is permitted to collect the postal receipt number from the registry and to submit postal track report prior to the next date of listing. Next para, in respect of service by Dusty Mode, comma, the learned counsel for the petitioner shall route the process through the registry of the court and upon service, comma, an affidavit of service shall be filed prior to the next date of listing. Next para. List on, give a date after we get.
much obliged, Your Lordship.
Yes, what is this interlocutory application for? What is this interlocutory application for?
For the amendment of the cost title and then to furnish the fresh address.
For
In respect
amendment
to
of the
respondent
cost
number
title
2.
of respondent number 2.
Yes, sir.
Okay. So if we allow this application?
Lordship, I'm not responding to. I'm
No, no,
other
no.
respondent.
You're the state. But change of the nomenclature of respondent number 2, new address is given. Okay. By filing this, okay. By filing this interlocutory application, comma, the applicant, who is the lead petitioner in the connected writ petition, has prayed for allowing amendment to the cost title in respect of respondent number 2, comma, namely, comma, Jainco Enterprise. Full stop. Next paragraph, Mr.
T. Chishi.
Comma, learned counsel for the applicant has submitted that the respondent number 2 has that the applicant has been able to collect 2 new addresses of the respondent number 2, which is sought to be brought on record. Next paragraph, we have heard Mrs. G. Atil, an additional senior government advocate representing respondent number 1. 1, 4, 1 and 4. Full stop. In view of the nature of explanation given, comma, the prayer is allowed. The applicant is permitted to bring on record the new addresses of the connected writ petition. Full stop. This application stands disposed of. And in writ petition, you write, heard so and so. In view of the order passed today in the connected IS Civil 165 AP of 2024, whereby amendment of cost title in respect of respondent number 2 is allowed, comma, the learned counsel for the petitioner shall provide a freshly typed copy of the cost title to the registry, and on receipt of the same, comma, the registry shall incorporate the amended cost title in the writ petition. Next paragraph. Pending amendment of the cost title, comma, the petitioner is permitted to take first steps for service of notice on the respondent number 2 at all the 3 addresses by registered post with AD. Next part, the notice is made returnable on date. Not wait. 24/10/22. Next paragraph, the learned counsel for the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph, list on so and so.
Supply sir. My lord, this is IEC for the last occasion day before yesterday.
Oh, yes,
Made a
yes,
mention.
yes, I understand. Your name I forgot. Your name?
Tapi Omu.
Huh?
It is there in the course. Tapi Omu.
Tapiomo, learned
Yes.
counsel for the applicant also heard.
Ma'am, I'm appearing on the respondent number 2, my lord.
Okay, and Mr. D.K. Boro, learned counsel for respondent number 2. And Mr. M. Kato, learned DSGI appearing for respondent number 1. Next para. This interlocutory application has been filed by the filed for extension of the interim order dated 12/7/2022.
Yes. In writ petition
In the
203.
connected WPC 203 of 2024 within bracket, formerly WPC 4614 of 2022. Next paragraph, the learned counsel for the applicant has submitted that the matter was listed on 18/9/2024 no, sorry, 25/9/2024. And the matter was mentioned for which matter was mentioned and allowed. First of, however, due to inadvertent omission, he had he omitted to have the interim order extended. Full stop. Next paragraph. Although the learned counsel for the opposite parties have opposed the prayer, you say not however, the counsel has opposed the prayer. Next paragraph. We take note of the fact that on what was the date? Day before yesterday? It was, what was the date yesterday? Day before yesterday? 18.
18th May.
Main order, 20.
No, this last date when the matter was fixed for 18/9.
18.
So
18/9.
the court recollects that on 18/9/2024, after the order was signed and uploaded, the learned counsel for the applicant did make an oral prayer for extension of the interim order. Full stop. However, as the order was uploaded, the order could not be altered. Next paragraph. Accordingly, the court finds good and sufficient cause for the learned counsel for the applicant to have omitted to make a prayer for extension of the interim order. Full stop. Next paragraph. Accordingly, the prayer made in this interlocutory application stands allowed. Full stop. Consequential orders would be passed in the connected writ petition. In the writ petition, you write, heard so and so. Let's say, in view of the order passed in IA Civil 174 AP of 2024, the interim order passed on 21/8/2024 as extended by order dated 4/9/2024, is further extended till the next date of listing. Let's stop. Next paragraph. List on 25/9/2024, as ordered earlier. Okay.
Also applies.
Hello, blackmail.
Yes.
Your Lordship. And before this honorable court only seeking direction upon the respondent number 3 to take up the complaint case which is pending before respondent number 3
Just a
since
moment.
September 2023.
Just a moment.
Last occasion, Lordship, notice was issued, in Lordship. It was observed that
I'm just give me 2 minutes. I forgot the context, so therefore I'm just refreshing my memory. Yes, now I understand. Yes, what do you have to say?
Lordship, last occasion, notice was issued, Lordship, and it was observed that this pending of this WP shall not be a part to the dispose of the representation filed by the petitioner. It was already observed.
21/6/2024.
Your Lordship, on
Where
the
is that 21/6/2024? Where is that?
208/24.
21/6/2024, where is that?
21/6. Your Lordship is annexure number 7, page number 38.
38.
Yes, Your Lordship.
Did you produce a certified copy of the order before the authorities? That
Yes, yes.
DLRSO, where is that? Where is
Your
the,
Lord, that was not annexed in this petition because,
no, we passed an order.
yes, Your Lordship.
Please follow us. We have passed an order on 2/8/2024. This 2/8/2024 certified copy, did you produce before the authorities?
Yes, Your Lordship, my colleague had served that order copy, and next Monday, Tuesday, that is on 8 August.
You don't have the document.
Your
You
Lordship,
don't have the document of the certificate copy being handed over.
yes, I've already handed over on 8 October, 8 August.
On 8th August.
8 August, yes, Lordship. That although that record is not with me that right now. Your Lordship, only issue is that my
No,
complaint is
it's
pending.
not a, you see, that's not a question. The notice on the others are not served. We are just asking for a handle to pass an order. But if you don't proceed, produce a proof. It's very difficult. Can you produce it on Monday?
Yes, sir.
Okay. अभी हो जाएगा लिस्टिंग मंडे हो जाएगा ओके the learned counsel for the petitioner submits that he will produce a copy of proof of submission of certified copy of the order dated 2/8/2024 to the District Land Record Settlement Officer, within bracket respond number 3. Next, brother, as per the office note, the registry has sent the steps on respond number 4 on 6/8. Sorry, on 7/8/2024. Stop accordingly. The registry shall put up the postal receipt number and the date of postage in the office note so as to enable the court to pass an appropriate order on the next date. Next para, list on Monday. You tell them to give the postal receipt number here in the office note. Huh? Yes,
May it please your lordship.
Mr. Dutta.
In this case, my friend has appeared on behalf of the bank and they have filed their affidavit, my lord. This matter, I seek some time to file my rejoinder, my lord. There is some issues, my lord, regarding maintainability as well as, my lord, on some factual dispute,
No, but you had made an offer
my lord.
Did you pay that money? No.
Actually, my lord, what appears now from this, the affidavit filed by them, has not taken into account the amount I have already paid after the, the issuance of the certificate. A huge amount has been paid, and I'll place all those things, my lord, on record, that I have got the proof of those payments also. So even thereafter, I have offered them 50 lakhs, which was rejected.
No, 50 lakh is, see, out of the amount, 50 lakh is too small.
Actually, my lord, if I place those records, my lord, that the amount which has already been paid by the petitioner.
You see, I will tell you, very clearly will tell you. First, there is an order of the DRT. An attachment order has already been issued.
My lord.
After issuance of an order of attachment,
My lord.
to entertain a writ petition.
My lord, I know my
Very
limitations, my
difficult.
lord. I know my limitations, my lord. Therefore, my lord, I beg to your, before your lordship, that I'll make
No.
my submissions on this issue, my lord, whether my lord, bar under section 30, whatever.
No,
my
there is
friend
a
has
very
raised.
recent judgment of Supreme Court 2024. Where is that? After 2022, again, there is a 24, there is a judgment. Coming down very heavily on courts.
Time to do. I'm ready to.
Invent. 24. Nowadays, I don't read, I don't remember.
And so far, another case regarding the OTS, there is also a 2024.
Yes, this is Gawai. Yes, this one. It's very difficult order.
Last para, in the last few.
Huh?
Actually, my lord, I could not go through these judgments also, whatever he has referred in his
No,
affidavit.
I also don't go to the
My lord.
judgment, but I have read it. Incidentally, this came to our notice. Because this is,
The last page.
because here you see, in this order, it says that 226 should not be entertained. It's a,
Understand, my lord. I understand my limitations. My lord, what has happened in this, judgment was passed in 2017. 2017, 2018, I have made.
you have seen the video, it is being circulated, I have seen it twice or thrice. There is a ice cream vendor with whom it's a, I think, Thai or Korean ice cream vendor. When you go to him to take ice cream, you have seen that, no?
No.
It's very beautiful. There's an ice cream chain in the country. It's there in many cities. I don't remember. Even my wife had gone there.
My friend knows me Turkish.
My wife had gone there. They when they prepare an ice cream and give it, they just remove the stick. You have to catch it. Once you catch it, it is free. And you can't catch it. My wife tried, she couldn't. So you see, I'm drawing a parallel.
I'll satisfy your lordship on this issue. my lord.
You
I'll
say that
satisfy.
50,000 will pay.
I'll satisfy.
But this 50,000 is not going
50
to the
lakhs.
city.
I understand, my lord.
Total outstanding,
My lord,
total outstanding is more than 1 crore.
More than 1 crore, good. But my lord, after the issuance of the certificate, I had some fixed deposit with them. They cannot deny this.
No.
They
That
have,
has-
I have
that
the
has been
proof. I have
adjusted
proof.
already
I
in the-
can place it on record, my lord. I had some fixed deposit with them as security. The matured value of which was 53 lakh 76, which has been, my lord, adjusted in 2019. These are not on record. My lord, amount
You
of,
see,
my lord,
everything is on record.
my lord,
Everything is on record.
they have not placed this, my lord. I have seen, but although I could not go through very thoroughly.
You see, at one point of time, there was a higher dues. What was the original dues? 3 crore something.
Yes.
Where is that?
We have enclosed in our affidavit, the latest outstanding.
You see, I don't remember because I'm very forgetful. There's a huge amount, and then they have adjusted, and then they went to the DRT, and the DRT there is an adjustment order. Then there are here I did not find the statement of account. I think you are not annexed here. or even if you have, I missed it out. Statement of accounts is not here.
Not telling.
Therefore, we can't identify. Have you produced the statement of account?
Yes,
Where is that?
in our affidavit. Last page of,
That is why we said we're in a very, very difficult situation you are putting us.
page number 39.
Page number 39. Oh, 39 will not be there now, it's a new number.
317 or 316. Both are matters of same.
This Neetu Enterprise, sheet number 1 and two page
It is also there, you know.
of statement.
Statement is there.
Hmm.
And
Since 2013, they have produced. Correct.
the interest calculation sheet is also there. Page number 1.
Now you see this, there's an entry of 34/2018 deposit transfer. Deposit transfer is always their internal entry. And then it goes to the interest.
Mr. Lordship comes to page number 114.
Page number
114.
114, yes.
Yes, after the certificate was issued, this is the calculation that has been presented before the recovery officer.
I don't hear this 20
Here
lakhs
is the,
have come.
your Lordship will see, this is the recovery we have shown.
20
In the
lakhs.
recovery part,
No, there's, in which bank is this? State Bank?
State Bank.
In State Bank, you always give a consolidated statement along with the fixed deposit. Where's the,
Yeah, here, Lordship.
which one?
Page number 114.
114? This is a fixed deposit account?
No.
No.
Here,
No,
this amount, recovery is amount, recovery.
No. I just, she wants to know about the.
Yes, that is what I'm stating. That is what I'm stating. 2018, 1/4/2018. Then 34/2018.
1/4/2018.
Below 20 lakhs 50,000.
Yes.
Yes.
Fixed deposits have been adjusted.
Yes, then 3 lakh rupees.
Then 3 lakh. This is then 6 lakhs.
Okay, then 8,83,000.
8 lakh.
Because they were not depositing there at that time.
This.
Cash money they are not depositing because it is after the certificate
Those
issue.
are fixed
Yes.
deposits.
No, my lord, 45 lakhs, which has been, my lord, matured value was 53 lakhs 76. I have got documents, my lord. I could not prepare the affidavit today, my lord, because only I got it on day before.
You see, what happens in the second set of documents also, they have reflected the payments made.
Yes.
One amount is 32 lakhs 12,000, which is matured on,
You
which
see
was
that
lying with
those
them.
deposit transfers.
We have
are
given
finding
the-
it that you have to disclose that this is a false statement.
Uh,
It can't be because you have never protested.
Oh, sorry.
You see, the bank will do everything. They may do everything bad.
My lord,
The bank may do everything bad,
my lord.
but in accounts, they will not manipulate. Because then the officer goes to jail. If he has withdrawn your fixed deposits and does not reflect in the statement of account, he knows that he will be going to jail.
I'll place it before your lordship, my lord.
It's
I have got
not there.
document, my lord. That document is there.
No, you
I
have the
have seen.
document, but you see, you don't compare it with the statement of account, so we won't understand.
Well, let them come and say, my lord, where is that
No,
amount?
we
gone?
understand, we read this. You see,
45 lakhs, my lord, my client has instructed me the 53 lakhs was the matured value in 18, 12, 19. Where is it?
statement. to overcome with a documentary statement is a very difficult position.
Well, I'll not take your lordship to calculate all those things. Roughly, I will place before this court that what are the amounts, my lord, already adjusted, and according to me, my lord, what should be.
You see, we are living in a digital world. Correct? The State Bank of India sends a digital copy of the statement of account with every month in email. Correct? If your client has not applied for a e-statement.
He has, my lord, he has not been furnished with.
It
He has
can't happen.
every day, even day before he visited the office, and after the matter goes to
No, no.
stress
You see,
recovery.
they will not give you a statement account when it's a stress asset.
Yes, what?
But through court, you can always get it because the statement account, they keep it frozen. Because it does not, because you see, what happens is that from the branch, it goes to the stressed account.
Yes, my lord.
And therefore, the branch does not maintain a ledger.
Everything goes there.
Everything goes to the stress bank account.
Yes, my lord.
So in stress bank, if you go and apply, they will give you a copy.
My lord,
I
that's
have
what.
not come across a situation where the stressed assets branch does not give you a copy.
When you are
My
giving
lord,
here,
my lord, my prayer is
can
that may.
can easily be given them.
My lord,
When you are giving it here, copies also served with them. So naturally they will give.
here the amount
There's
is
nothing to
not,
hide here.
my lord, not, the amount is not incorporated, what I'm trying to say, my lord, in this
This
statement.
can't happen. It's not possible.
That's
It's
what,
just
my
not
lord,
possible. You ask your client, go outside and ask your client to give us the account number of the deposit.
Yes.
We'll
yes,
give
he
you-
has got, my lord, 1 week time may be given, I'll place it before your lordship.
issue-
I have
before
got,
the
it.
recovery
I have
of-
seen, my lord, with the client, my lord. I have seen that document with the client, so I'll place it before your lordship,
Looking
my
at
lord.
a document, you see, I may have a document. But I may have encashed that, what you call that.
No, but they have to say then I have encashed it. It was lying with them
It's here.
as security, my lord.
It's here.
No, not this amount, my lord, not this amount, whatever they have disclosed, not this amount.
Let the matter be raised before the recovery officer.
I'll
He
do
is the
that, I'll do
appropriate
that,
person.
my lord, but let me, my lord, just produce it before your lordship.
No, the recovery proceeding is not stayed.
Not state, my
Not
lord.
state.
Not state.
Not state. They can easily make a
No.
prayer there.
Then what is the bar you proceed with there? What is the bar if there is no stay?
Because I know my limitations, I'm not insisting for that, my lord.
They have come, they have
I'll just-
basically challenged two things, Lord. One is OTS and one is the notice issued by the recovery officer. These are the two things they have challenged in the writ petition. Basically two things. So if they are aggrieved by any order, either they can file an appeal or they can approach the DRT
My lord,
recovery
I
officer.
appeal, there is some difficulty. That's why I'm before this court. My lord, I'll address this court, my lord, on this
Not a
issue.
difficulty.
My lord, the
I was
difficulty.
once there where you are standing.
My lord.
There is no
My
difficulty.
lord, I know this, my lordship is aware, my lord. So, my lord, here I have to deposit the 50% of the amount, whatever is the certificate amount. My
25%.
case is this, that
75%.
70, nowadays, 30, section 30 appeal.
Section no.
30 appeal,
25%. I think
Then
50%. 50%. So my case is that they are not entitled to this amount, my lord. That's what I'm trying to project before your lordship, my lord.
then also we can't interfere. For that, the Supreme Court in the earlier judgment is very clear. Not in this, but in the earlier judgment. It's very clear. Account is something we can't see.
I'm just seeking an opportunity, my lord.
At least,
I'll
at least,
place.
the best option will be for them, lordship, to approach the recovery officer, because they don't have to file an appeal before the recovery officer. They can just file an application. See, this is the documents that fixed deposits, which may not have been adjusted by.
My lord,
Yes.
in that case,
Yes,
my
the
lord, let
recovery
this
officer
matter
has the
remain
ample
pending,
power.
my lord. Let this matter remain pending and I'll file appropriate petition there.
But Ms. P. Chakravarti, learned counsel for the petitioner, also heard Mr. S. Datta, learned counsel for the respondent bank. Any other parties?
No, all the banks.
Respondent bank.
Okay.
Next para. The learned counsel for the petitioner has submitted that as per instructions received by her, there are certain fixed deposits of the petitioner which has been encashed by the respondent bank comma, which is not disclosed in the statement of accounts. Full stop. Next para. The learned counsel for the respondent bank has vehemently opposed this said statement, and it is submitted that the statement of accounts of the petitioner is enclosed along with his affidavit in opposition, which includes transactions from the year 2013. Full stop. He has submitted that the debit entries in the account show clearly discloses the amount adjusted on encashment of the fixed deposits.
It's not written in. It's not written there.
That's okay.
Just recoveries.
Which is shown as recovery without indicating the account numbers. No, fixed deposit numbers. Next para. It is also submitted that if the that a recovery proceeding is pending before the Debts Recovery Tribunal, Guwahati, and if the petitioner has any document that his fixed deposit has not been the adjustment of his fixed deposit is not reflected in the statement of account, he can, the petitioner can produce such document before the recovery officer, and the recovery officer would definitely look into that grievance.
Fixed deposit, other payments, there are some other payments also.
All other,
any other.
all of it, whatever it is.
He also submits that any other grievance of the petitioner about non-adjustment of not reflecting recoveries in her statement of account, in the petitioner's statement of account, can also be verified by the recovery officer. Next para, it is submitted that use is to be recovered from the petitioner, and therefore he has placed reliance on the case of PHR Invent Educational Society, PHR Invent INVENT Educational Society versus UCO Bank and others, 2024 INSC 297, decided by a three-judge bench of the Supreme Court of India, wherein serious concern has been expressed on the entertaining of writ petitions under Article 226 of the Constitution of India by ignoring the availability of statutory remedies under the what is the name of the act? Recovery?
Recovery of debts and bankruptcy.
Recovery of Debts and Bankruptcy Act from 1993 and SARFAESI Act. So accordingly, they submitted that this petition would not be maintainable. Next paragraph. Be there as it may, comma, the court is inclined to provide that the pendency of this, that notwithstanding the pendency of this writ petition, comma, if the petitioner has any grievance regarding non-reflecting of adjustment of the petitioner's fixed deposits or any other recoveries made by the bank in the petitioner's statement of account, comma, the petitioner would move the recovery officer, comma, Debts Recovery Tribunal to bring the said fact to its notice. And we hope and trust that the recovery officer will on receipt of such information shall carefully scrutinize the grievance of the petitioner. Full stop. Next para. The pendency of this writ petition shall not be a bar for the recovery officer, Debt Recovery Tribunal to proceed with the matter. Matter can be disposed of.
And let it remain pending, my lord.
No, I'm not disposing it off. She wants to be.
Oh, all right, all right, all right.
Dispose it off. However, as indicated in the previous order of this court dated 14/8/2024, the liberty granted to the petitioners to make a mention will still be available to the petitioner.
Next matter is also same.
Take this back, list on. Give a
Also, you
date,
can keep-
next date.
Keep it.
No, it's okay. Next time we produce it because.
No, this is not also.
Actually,
This is not also.
He has submitted that an affidavit in opposition has been filed. वो तो हाई है ना? Affidavit in opposition का बता गया इसमें. Okay. And this same.
Same, but here there is no issue of.
Payment adjustments.
No.
Here only, I want to settle this. Actually, the certificate was for 66 lakhs. Now I am ready to pay 50 lakhs, which the bank is not accepting.
It's here also the total outstanding is more than 1 crore.
Here also it is 1 crore.
No more than 1 crore. Here also OTS had once failed.
You use some extra words, which always I don't know why my side goes to that word only. He's saying that the dues are 1 crore. And you write somewhere that the petitioner is a small lady.
Actually, my lord,
Now, I don't know.
nowadays, my lord, 1 crore is nothing.
Because
The small
I was
business.
just thinking when I was reading this, that
Actually,
okay,
this-
perhaps in the eyes of the world, I'm a big man, but I've never seen 1 crore.
Yeah, for us, my lord, this is a big
I
amount.
don't know. I'm not speaking for Mr. Modi or Mr.
The outstanding here was 66 lakhs, my lord.
Tagum sitting behind. Correct. I'm not speaking for you. 1 crore rupees for you to will be easy. Mr. Modi, any comment? No comment. So you see, there are two exceptions here. I don't know why, but my eyes goes to those few words.
I remember that line from Godfather. I remember the line.
You know that?
Yeah.
Can you tell us?
A lawyer with a brief.
A
can
lawyer with a briefcase.
Briefcase can steal more money.
No, can earn more money.
The steal, this word is steal.
Kill.
Steal.
Oh, steal. Steal.
Yes.
Can steal more money than
than a
men
man
with
with a gun.
gun and masks. That is that line I wanted. Very good. This is what I wanted to tell the young guy.
Appropriate.
So, lawyer with a briefcase can do wonders. So, briefcase lawyer, I do not like, that's why. Mr. Tagum, I'll tell you one story. I was a young junior. My practice was not more than 1 or 2 months. And I was holding a diary, which is small, pocket diary, very small diary to take dates. And one APP who saw me writing in that diary, he told me that, young boy, you are writing in a small diary. How do you plan to become big? Because you must always have a big diary. And then with my limited earning at that point of time, I got still a small diary. There's a Gupta's diary, it's small, but it is big. It's a code edition type. So I've got that, and next day I went to him and I told him that, sir, I've got this. He said that, well, still not big. So you have a bigger diary and become big. And let me tell you, I got a big diary and I was never dissatisfied after that. So I always, with very great respect, I very fondly remember the learned APUs no more, who have given me an advice that a lawyer should always have a big diary. So that's my story.
Actually, my lord, we are discussing your lordship's diary. They used to be filled up.
Huh?
We were discussing during the lordship while practicing. Diary used to be filled up, big diaries.
No, I don't say it was filled up, but yes, the diary had to be a big diary.
No, I still remember.
We were discussing.
If you permit me, used to go to the DRT personally go there and check the dates. That I remember.
That's great. But here, you see what is your prayer here, Mrs. Chakravarti?
Here, I want to settle this in 50 lakhs, and that is also one go. We can make the payments. 66 lakh was the outstanding.
What is this 24/4 order? Where is that?
24. Oh, this is by mistake. It has come reflected in the order. Actually, the amount outstanding, the certificate.
No. There's a defect, formal defect in your order. Where is this 24/4?
24/4.
Order under challenge.
Attachment.
Annexure 4 is 24/4. Correct. This is the order you have challenged.
Yes, my lord.
Correct.
Yes, my lord. Yes, my lord. So here,
But
my
after this judgment of OA 154 of 2020 attaining finality, how can you challenge this order?
actually, my lord, here, my prayer is that since I am ready to pay, there is
No, that is something else. It's got nothing to do with the challenge. I am on the nature of challenge. 24/4, you say that there is a judgment of the DRT, which is ex parte.
Ex parte.
Ex parte judgment, you have not asked for setting aside.
Setting aside.
Correct. Now you are asking
Want to pay, my
a
lord.
challenge to the order of attachment. It's not permissible. You have to dismiss this writ petition. Order of the court to take physical possession.
My lord,
You can't challenge that order.
without challenging that expertise.
Because even against this order, there's an appeal before the Debt Recovery Tribunal.
Yes, my lord.
Section 30.
Yes, my
And
lord.
after
I
this,
didn't go to all this because I am ready to pay, and that too at one go.
but this has to be dismissed. We can't allow this to be, because there's a appellate forum available. This is the order of the recovery officer.
Yes, my lord.
Yes, correct. Against this, an appeal will lie.
Section 30.
Yes,
Section
30.
30. So I think this matter has to be closed. If you want to settle the matter, we still give you a leave. You can apply before the Debt Recovery Tribunal, this
That will
bank
be- Yes,
for settlement.
that will be better.
Will be the authority before whom her application for one-time settlement can be filed.
One-time settlement, year-wise scheme comes out. Now there is no scheme. So that
No,
is the
even
difference.
otherwise, who is the person who can take a decision? Which authority will
These
normally
are
not take
also
it?
gone to the stress test.
More than 1 crore, then it has to be, I think.
Just go out and talk to somebody and come back.
Huh?
Go out and talk to somebody and come back. The competent authority to entertain application for compromise. But Mr. Chakravarti, we are closing this matter because we can't permit that. Had Ms. P. Chakravarti done it counsel for the petitioner. Also heard Mr. S. Dattal and it counsel for the respondents. Next, para. The case of the petitioner is that she is a borrower of the respondent number one bank. And had availed a cash credit loan of rupees 48 lakh for farming and marketing of cardamom. The loan was secured by executing a mortgage in respect of a particular land in question. Due to reasons beyond the control of the petitioner, there was a failure in business and the account of the petitioner was classified as NPA on 28/11/2017. Consequently, the respondent bank approached the Debt Recovery Tribunal by filing a recovery claim for a sum of rupees 66, 11, 354.72. Which was registered as OA number 154 of 2020. Next paragraph. The original application was decided ex parte by order dated 23/4/2021. For recovery of the said amount, a recovery proceeding was registered. In course of time, the recovery officer had passed the impugn order dated 24/4/2024 thereby appointing a receiver for taking physical possession of the property of the petitioner on conditions which contain in the said order. Order dated 24/4/2024. Accordingly, the petitioner is assailed. The said order of the recovery officer from a Debt Recovery Tribunal, Guwahati, passed in connection with OA 154 of 2020, in which recovery certificate number 220 of 2021 was issued. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner has submitted OTS proposal for settlement of the dues at rupees 40 lakh by a proposal dated 17/7/2024 and has also deposited upfront money of rupees 50,000, which is claimed to be as per the RBI guidelines. Full stop. However, the respondent bank had rejected the one-time settlement proposal of the petitioner on the by a communication dated 3/8/2024 on the ground that the proposal is undervalued. Next paragraph. The learned counsel for the petitioner submits that the petitioner, that the property of the petitioner is a residential house and that she is residing there with her family, and the petitioner would suffer irreparable loss and injury if she is dispossessed from her property. Accordingly, comment is submitted that as the petitioner is ready and willing to settle the matter on compromise, she has approached this court under Article 226 of the Constitution of India, and has said the said Indian order dated 24/4/2024. Intending that the matter would be compromised. Next paragraph. Contract, the learned counsel for the respondents has questioned the maintainability of this writ petition, for which he places reliance on the case of same case.
Bijnor.
Huh?
Bijnor's case. This is the OTS.
Yes, sir. The Bijnor BIJNOR Urban Cooperative Bank Limited and others versus Meenlal, MEENAL Agarwal, AGARWL and others.
Paragraph 11.
No, this is a reported case. What is the citation? This is sometime in 22. This is within bracket 2023, bracket was 2 SCC 805 equivalent to within bracket 2021, bracket was 0 Supreme within bracket SC 820.
Paragraph 11.
It is submitted that by the said judgment, the Supreme Court of India has held that a writ petition for being given benefit of OTS cannot be paid as a matter of right. Stop. Next, justifying the rejection of the OTS proposal on the ground that it is undervalued. It is submitted that in the said decision, the Supreme Court of India has also held that if the bank public financial institution is of the opinion that the loanee has the capacity to make the payment and obligor that the bank public financial institution is able to recover the entire loan amount even by auctioning the mortgaged property, public secured property, either from the loanee and obligor guarantor, the bank would be justified in refusing to grant the benefit under the OTS scheme. Full stop.
The conclusive paragraph is in the last paragraph. The sum and substance of the aforesaid discussion will be that no writ of mandamus can be issued by.
Let me already written. Next one. In the present case in hand, it is not in dispute that there is an ex parte judgment, an order by the Debts Recovery Tribunal, Guwahati, in OA number 154 of 2020, which was passed on 23/4/2021. Which is evident from the copy of Annexure 1 to the writ petition. Full stop. The said order has attained finality, which is also not disputed by the petitioner. Full stop. The petitioner has annexed a copy of a notice of eviction dated issued on 23/5/2023 by the Debts Recovery Tribunal. As Annexure 3. And subsequently, the impugn order dated 24/4/2024 was passed, appointing a receiver to take physical possession of the property. Post of the said sequence also discloses that the recovery certificate issued by the Debts Recovery Tribunal, Guwahati, in favor of the respondent bank has not yet been made. Next paragraph. Under such circumstances, it cannot be held that the order of appointment of receiver to take over the movable and immovable property of the petitioner by the impugn order dated 24/4/2024 is illegal or untenable in any view of the matter. Next paragraph. The learned counsel for the petitioner has submitted that as the petitioner seeks indulgence of the court to allow the petitioner to submit an OTS proposal, she also prays that the matter be kept pending. Next paragraph. In this regard, the court is of the considered opinion that keeping the matter pending would not serve the interest of justice. stop because the recovery proceedings are already initiated. And there's no ground whatsoever to hold that the said order, the said impugn order dated 24/4/2024 ought not to be acted upon. Next, therefore, the court does not find any merit in the petition and the same is dismissed. Next para, however, before parting with the records, the court is inclined to observe that as the learned counsel for the petitioner, upon instructions, has submitted that the petitioner desires to make an offer to the respondent bank for out of court compromise of the matter, either by way of OTS or in any other mode. On a query of the court, the learned counsel for the respondents has submitted that the competent authority to entertain a request for settlement in this case where the claim amount has now crossed ₹1 crore.
More than what?
More 1 crore. Taking into account the interest component. The competent officer is, who is the competent officer?
There is no competent officer, because there are committees, separate committees also.
Okay.
For, say for 50 lakhs, 1 crore, above 1 crore. So it is a set of committee is formed.
So she will give it to whom?
She may give it to the SARB, Jorat.
SARB.
Stress Assess Recovery Branch.
It says that
But they are not the competent authority, they will channelize it.
such an application can be handed over to the SARB within bracket Stress Asset Recovery Branch, Jorat, who would forward the application to the competent authority. It is submitted that there are committees constituted to have financial power for various amounts, and therefore he is not in a position to inform as to which committee will look into the matter. Next paragraph. Accordingly, it is provided that in the event the application of the petitioner for compromise or one-time settlement, etc., is submitted before the SARB, Jorat, the said application shall be forwarded to the competent authority for consideration, and a decision thereon shall be conveyed to the petitioner within a period of 4 weeks on an email address to be given, provided by the petitioner.
Lordship, if I may, if they, because there are norms, if you file OTS proposal, Lordship is ever
10%.
No, 25%. As per RBI guidelines, 25% of the total outstanding dues has to be deposited.
That will do.
Because otherwise, that will.
Otherwise, that will not be acceptable. That I know.
Learned counsel for the respondent bank further submits that normally there would be a requirement to deposit at least 25% of the defaulted amount.
Total outstanding dues.
The total outstanding dues along with such proposal. And therefore, while depositing, and therefore he submits that while before depositing that the prayer, such prayer, the petitioner should ascertain as to what would be the actual amount required to be deposited. from the concerned officer at the SARB Johat. The petitioner shall take note of the said submission made by the learned counsel for the respondents. Stop. Next para with such observation as indicated above, comment this petition stands dismissed.
Any of this?
I think I'll not be able to take up any other matter. This is criminal petition. Will take some time.
Milord, item number 32, Milord, Lordship may kindly fix any day, if possible, Milord. If your Lordship kindly accommodate on 30th of September or any date as your Lordship, please. Item 32. 30th September or any day.
Huh?
I'm for item number 32, Milord. I'm for item criminal petition.
Item 13.
Or
Mr. Singh,
Oh.
what is the matter about? Mr. Singh, what
my
is the
lord,
matter?
my
sir?
item is for the
This, my lord, this
For
is
setting
regard
aside
for
the bail order.
cancellation of the bail granted by the trial court, my lord.
Okay, this petition is against that.
Yes, my lord.
Okay, what is the order? What is the order dated?
My lord, order is dated 26/2024. My lord, because at least I'll be needing at least 45 minutes argument in this matter. So even your lordship is taking on Monday. I don't have any this thing.
No, not
But-
on Monday. We have made many matters fixed.
My lord, as your lordship, please, any day. As your lordship, any day. Because the parameters that has to be taken in the plethora of judgment passed by the apex court on the heinous crime has not been taken into consideration while passing this bail order. My lord, I'll try to satisfy your lordship. Any day may
But
be
the
fixed.
difficulties are the dates. Can I give it on 26th?
My lord.
26th?
My lord,
My lord, no issue.
my lord, 26. My lord, if I'm, my lord, it's okay, 26, okay, my lord.
Huh?
It's okay, my lord, 26.
Okay. Due to positive time, matter cannot be taken up today. Next, by the counsel for the petitioner submits to RVC that this criminal petition is for cancellation of bail. Next, para Mr. G. Tadul and an AVP as well as Mr. T. Dagum and a counsel for the private respondent are present. Next, para is agreed to by both sides, released on 26/9/2024.
My lord.
Deeply obliged.
Obliged, my lord.
May I also? Honorable, Lordship, I call this bail application under section 483 BNSS 2023, Your Lordship. Also, page 13 is the FIR. Annexure 2.
You were arrested on
Arrested on 11/06/2024. Oh,
11/6/94.
yes, 11/60, 11/6/24. June
24.
11. Till then,
How many days today?
more than 100 days. More than 100 days.
More than 100 days.
Yes, Your Lordship. A charge sheet has been submitted and charges have been framed against the accused person, and on next date, evidence has been fixed.
Where is the FIR?
FIR is in page 13, Annexure 2. May I, Your Lordship? To the officer in charge police station, Koloriang, Kurungkume
I
district.
think
of
with
Nasik-
100 days, we'll have to grant him bail.
Yes, Your Lordship.
With more than 100 days in custody, we have to grant him bail.
Yes, Your Lordship, on 13/09/2024, I have filed.
Charge sheeted, Your Lordship.
Still, you see, charge sheet doesn't matter anything.
But
It's
we,
just a document now.
we have to go for merit also, to look over the merit of the case. Serious case cannot be easily granted bail because bail can be granted after considering the gravity of the offense, severity
Oh, what is the
of the
problem?
punishment.
What is the guarantee? He has just beaten them up, destroyed some household goods.
Yes, Your Lordship,
Look
in
at the
fact-
FIR. In the morning, he came without any reason, beat them up with wooden stick.
informant is, victim is the wife of the accused person, Your Lordship.
Here sustained grievous injury over the head.
Yes, yes, please read.
So, since matter is charge sheeted, we have to peruse LCR, TCR.
No, Your Lordship, I have annexed the latest,
Don't interrupt.
latest
me.
order. Yes,
Don't
Your Lordship.
interrupt. He's trying to say something. Yes. Where is the charge sheet?
Yes, charge sheet is in
Page?
from page 17 to
Page?
page 17.
17.
Yes, 17. 17, from 17 to 54, what I have received in 207, you know. And regarding this, Your Lordship, the MLC report. MLC report is also in the page number 49, which is the victim MLC report, Your Lordship. It is
Simple injury.
yeah, simple injury. And his mother, EIIU is also simple injury, 51. Informant and his mother. Simple injury, Your Lordship. And 53 is, Your Lordship, the agreement of separation passed by the Old Sarli Polosong Circle Gangbora Welfare Association. Decree, Your Lordship, this is.
It seems from the record that there is a great marital discord between the husband and wife. So, at least informant here, victim has to be examined first for granting bail. Otherwise, she can be influenced, tortured, threatened again. So TCR is necessary to bear it. So what stage at now is pending?
Your Lordship, I have annexed the latest case court order in page 14. It's annexed 3. Page 14. Since I am the learned defense legal aid counsel for the accused person in the trial court, learned below.
Here charge was framed.
Yes, Your Lordship. And next date.
No, but if you're a habitual offender, in this order, it says you're a habitual offender. You beat up your wife regularly.
Yes, exactly. Within laws also.
But if that is your habit.
No, Your Lordship. That
you
is
have to
allegation.
keep
Your Lordship.
separated. No. What you call, you see here, you are making me read this page 40. This is more serious. You accuse the wife of having extramarital relationship with others, and therefore you beat up her regularly. Then you are a threat to her life.
They are living separately now also as per report.
Your Honor, we've been separated as per the Gangbora direction
But
till
you
1
go to
year,
her place at
more than
3
1
o'clock
year.
in the morning.
Your Lordship, we are staying separately.
506 also indicted.
But still, Mr.
PCR may be.
Mr. Tado, we are now. If it's 100 days.
It's more than 100 days.
But we'll have to give you a notice, we give you a notice, we take it up next week,
Yes.
we're giving you a notice. It's a bail application.
This is a matter of Colorian.
Following case number.
Issue notice on the, on the landed APP.
October 1.
Huh?
October 1. October 1, 1st October.
So in this bail application, the petitioner projects that he was arrested on 11/6/2024. And accordingly, the London Council for the petitioner submits that the petitioner is in jail since, for how many days?
More than 100 days.
No, you calculate, it's very easy to calculate.
102 days.
102 days.
Yes.
What's wrong? List on 1/10/2024.
Yes, 1st October. Definitely.
Because now.
PCR may be called.
Hmm?
PCR. Airport record.
Okay. In the meanwhile, the registry shall call for a scanned copy of the PCR. Full stop. Requisition for the same shall be sent by email with liberty to the learned concerned court to send the scanned copy of the TCR by email for being placed before the court. Okay.
Much.
So, requisition is TCR. Yes, Mr. Modi.
Yes. My lord, this is the direction against the order wherein I have been transferred from my lord Kanubari to Pasigat. Since my lord, I am in the Kanubari by the previous transfer order on 31st May 2023. Therefore, my lord, my tenure, 2 years of the tenure has not been completed till then, my lord.
Where is that order? Where is the transfer order?
My lord, the recent transfer order in
No,
page
the
number.
first transfer order.
First transfer order in page number 15, my lord.
15.
15, 1/5, annexure A, my lord. By this order, I have been transferred from my lord Namsai to Kanubari, and accordingly, I have joined here at the Kanubari, and while working there at the Kanubari, my lord.
No, here the word is used. In this page 15, word is used that executive engineer so-and-so is posted to the office of chief engineer so-and-so is hereby reposted to the office. Reposted means you are transferred back to your own home of the earlier posting.
My lord, whatsoever this had, I have been transferred from the Namsai, my lord. Then, my lord, in page number 16, my lord, the recent transfer.
But when were you transferred? Since you see. You see, this is, I don't understand. You see, read this order, page 15.
Page, my lord.
Page 15, 1/5. In partial modification of the order of 25/5/2023, you are sent back to your office. That means there was no transfer at all. This page 15 is not a transfer order. Transfer order was passed on 25/5. And before you could move 31/5, you are restored back to your place of posting. It's not a transfer. This goes. Now, where is the second transfer order?
In page number 16.
Page number 16.
My lord.
You're transferred to Pasighat.
So I have been transferred from
Yes.
Kanubari to Pasigat.
Yes.
So, my lord, being aggrieved of this transfer order, I have submitted a
Oh,
representation.
no, we can't. I have shown you, we can't interfere with this transfer. Your earlier tenure is not there. That caused me an anxiety. Your your posting in the earlier tenure is not given. And page 15, when you make me read, It's a retransfer, that means you have not been transferred at all. So Mr. Modi, no case is made out.
In fact, my lord, I was transferred from Namsai to Kanubari, my lord. The first the posting, my lord.
You see, I am reading you page 15. I have told you why I am reading in the manner which I am reading. 25.5 is the order of transfer. In modification of 25.5, 31.5 is passed. You can't be aggrieved. This is not a transfer. You have not made any statement earlier about the earlier posting. You conveniently start from that place.
My lord, it is very clear that is, my lord, in fact,
Mr.
from
Modi,
Namsai to Kanubari, my lord.
You see, so therefore there is only one transfer. Modi, I have shown you.
My lord.
We
But
can't-
my lord, what has been brought before me, my lord, that initially I was at the Namsai. And thereafter, my lord,
We are
I was
showing
retained
you,
at
you see, we are
Kanubari.
showing you 25.5 is your transfer order. It is modified and you are retransferred to your own office on 31.5. That means the transfer office was not there. After 3 months, you are transferred. You don't have a case.
Despite of that also, my lord, since the subsequent transfer order, that I have filed a representation before the authority, that I have, my
No,
lord,
that can't be
I have
entertained.
ventilated my representation.
That can't be entertained.
So, my lord, at least, even if, my lord, not enter into the merit of the case also, my lord, would not enter into the merit. This, at least my representation may be, my lord, directed to consider, my lord. Because what, my lord, on the particular ground I have sought for recalling and the cancellation of this transfer order is that, my lord, I am suffering from, my lord, eye cancer, and at the same time, many ailments like I am diabetic patient and the blood pressure. Therefore, my lord, and recently my treatment is going on at the Dibrugarh, who is nearest to the Kanubari, my lord. And to reach the Dibrugarh from the Kanubari, my lord, it took hardly two hours. Therefore, my lord, my medical treatment is going on at the Dibrugarh, and there is more easier than that of where I have been transferred, my lord, at Pasighat. So at least on the anticipation that my representation that at 10/9/24 may be considered. Therefore, till today, I have been waiting for, but my lord, I come to know that this transfer or this representation has not been attended, my lord. So at least I have the reason to be consider my representation if the respondent number 4, that is the superintending engineer coordination PWD, has attended, my lord. So at least, my lord, let my representation be considered. And at the same time, so far this transport is concerned, my lord, when the transport is made on the public interest, my lord, there should be one vice versa. There should be other person who has been transferred in my place.
That we don't know. How the government runs, we don't know. Yes, but you respond to his representation. You close him to repetition, but you pass an order.
Not that much.
How much? How many days?
Within 15 days.
Huh?
Within 10 days would be.
10 days, make it 10
Yes.
days. Don't take coercive action till then.
Yes, Lord.
Mr. C. Modi, learned counsel for the petitioner, has submitted that the petitioner was previously transferred by order dated 31/5/2023, and thereafter he was again transferred by an order dated 30/8/2024 from Namsai to Pasighat in a short tenure. It is also projected that the petitioner is suffering from certain I elements which is supported by the medical documents annexed to this writ petition. It is submitted that against the transfer, the petitioner has submitted a representation before the authorities on 10/9/2024 for retaining him at Kanu Bari, Kanubari. And accordingly, the present writ petition has been filed under Article 226 of the Constitution of India for interfering with the transfer order dated 30/8/2024. Next paragraph. The Ms. G. Ake, an additional senior government advocate, has opposed the prayer made in the writ petition. And it is submitted that the transfer is the prerogative of the employer, and therefore the court ought not to interfere with it. Next paragraph. On an examination of the office order dated 31/5/2023, it is seen that the petitioner was transferred by 20 or by the office order dated 31/5/2023 discloses that in partial modification of the office order dated 25/5/2023, the petitioner was reposted to the office of the executive engineer, Kanubari division. Therefore, the order dated 31/5/2023 is not an order of transfer, and therefore it is only an order of reposting. Therefore, the petitioner has been transferred only by an order dated 30/8/2024 from the office of executive engineer, Kanubari division, to the office of the chief engineer, Central Zone -B, PWD, Pasighat. Page 16. Next paragraph. Next paragraph. On a perusal of the representation dated 10/9/2024, which is addressed by the petitioner to the superintending engineer, coordination, PWD, we note that the said representation was sent by registered post on 30/9/2024. There's no material to show that the said representation has been received by the competent authority. Be that as it may, as the said representation is annexed to the writ petition, this Ms. Ete, how this Ms. Ete, how this representation can be sent to the authorities by, you have the email number of this person, superintendent engineer.
Lordship, I can get it. I don't have, I'm not having it right now.
You can give it to Mr. Modi, over by phone or by WhatsApp, send it to him.
Lordship.
Because this, even the superintendent engineer must get it. It was sent on 13th. Whether he's received it or we don't know.
Lordship, Monday, myself, I will also take instruction if they have received this. I will send it to WhatsApp.
No, because I wanted that he can mail it. If you can get it today, he can mail it tomorrow.
Yes, Lordship.
It'll be faster.
Yes.
If we wait till Monday, it delays the.
Yes, Saturday, Sunday. Yes, Lordship. I
Right.
do that.
Next paragraph. As we find that this the first transfer of the petitioner, comma, the court does not find any merit to entertain the debt petition. Post of the earlier tenure of the petitioner in the earlier place of posting is not disclosed in this debt petition. So therefore, comma, the debt petition is dismissed. Next paragraph. Be that as it may, comma, before parting with the records, comma, as the learned counsel for the petitioner has submitted that the medical documents annexed to the debt petition discloses that the petitioner is suffering from eye cancer, comma, the court is of the considered opinion that the petitioner be given a liberty to send the representation dated 10/9/2024 to the superintending engineer by email along with along the scanned copy of the certified copy of this order, along with all medical documents. In the event on receipt of such the said representation, comma, the superintending engineer, comma, coordination, comma, PWD shall take a decision on the said representation within a period of 10 days. Next paragraph. In the event the superintending engineer, comma, coordination, comma, PWD, comma, is not the competent authority, comma, he would forward the said representation to the competent authority. At the earliest. Next paragraph. It is also provided that any order which is passed on the representation passed by the submitted by the petitioner shall be communicated to the petitioner at his email address to be disclosed by the petitioner. And such reply would constitute due service of reply to the petitioner. Next paragraph. Till the period of 10 days from calculated from Mondays 23 from calculated from 23/9/2024 and or disposal of the representation, comma, the superintending engineer, comma, coordination, comma, PWD shall not initiate any coercive steps against the petitioner. Don't say dismiss, you say closed.
Yes.
10 days time.
Yes.
All right.
Outlets.
I've modified the word dismiss to disposed.
It is possible.